Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the civil, probate, and guardianship docket for Tuesday, June 30th, 2026. The time is now 2:02. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator, interpreter, and court coordinator for this session. Our probate court investigator is Liza Rodriguez. Video conference co-hosts this afternoon include Mr. Ernnandez, Ms. Reyes, Ms. Flores, Ms. Ramos, and Ms. Cuellar. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Rodriguez.
First in person, Solis Soto, page 3, number 5.
This is the estate of Maria Guadalupe Lopez, 2022 PB4 109L2. Court marks Ms. Soto present in person. Good afternoon.
Good afternoon, Your Honor.
Mr. Jose Luis Castillo, Jonathan Garcia Dávalos, Olivero Canales. Is any other lawyer present?
Mr. Garcia Dávalos should be approaching the bench, Your Honor. He's the one that filed the objection to the order.
This is his motion that his objection that we're set on. Patricia Garcia, Maria Guadalupe de Reyes, Jesus Manuel Lopez. Are there any parties present?
Your Honor, my client is not present, but she should be en route. Jonathan? Well, my client just arrived, Judge. My client is here, so we're just waiting on Mr. Garcia. Can we call the...
Patricia Garcia, are you? All right, court marks Patricia Garcia present. Raising your hand, I want you to unmute. I'm going to ask that you unmute your device, please. There's an unmute button at the bottom left of the device or screen. Press that button to join the audio.
Here we go. Yes, sir. Yes, sir.
Person on our left, on our right, your left, white shirt. Tell me your name, please.
Patricia Garcia.
Is this your client?
My client's in the courtroom, Judge. That might be another case.
It is another case, Your Honor.
All right, stand by. All right, then court marks no other persons present. I will place this case as the first contested matter on the court's docket without knowing anything else. Ms. Rodriguez.
Page 4, number 9.
In the matter of Jorge Umberto Coronado, cause number 2025 PB 658L2, court marks Ms. Soto present in person. Ms. Garcia is also present in person. Silvia Sepulveda, are you present?
She needs an interpreter, Your Honor.
We'll begin Spanish language interpretation now. Are you Silvia Sepulveda?
¿Es usted Silvia Sepúlveda?
Sí.
Yes.
Welcome to court. You're joining us by video conference.
Bienvenida al tribunal. Está con nosotros por medio de videoconferencia.
As you can see from your screen, your lawyer is present in person.
Como usted puede ver en su pantalla, su abogado se encuentra persona en el tribunal.
Ms. Soto?
Yes, Your Honor. So we are ready to proceed with the guardianship application. And I'd like to ask the court to take judicial notice of all the requirements that have been met and on file with the court.
Su señoría, estamos listos para proceder el día de hoy y que se tome notificación judicial de que todos los requisitos han sido interpuestos ante el archivo y el tribunal.
Are you also ready to proceed, Ms. Garcia?
Yes, sir.
¿Está usted lista para proceder, abogada García? Sí, su señoría.
Court takes judicial notice of the entire case file, including the criminal background.
El tribunal toma notificación judicial del archivo entero.
The medical certificate, certificate of compliance, certifications, posting, and service.
El tribunal toma notificación judicial de los certificados interpuestos, los citatorios por servicio personal y los demás requisitos.
Ms. Sepulveda, would you raise your right hand, please?
Señora Sepúlveda, por favor, levante su mano derecha.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Jura o afirma que el testimonio que dará ante el día de hoy será la verdad bajo el amparo de Dios.
Sí.
Yes.
You may lower your hand. Ms. Soto.
Yes, Your Honor. Ms. Sepulveda, are you the biological mother of Jorge Umberto Coronado?
Señora Sepúlveda, ¿es usted la madre biológica de Jorge Umberto Coronado?
Sí.
Yes.
And his date of birth is 12/5/2000?
La fecha del nacimiento de él es el 5 de diciembre del 2000.
Sí.
Yes.
And he currently resides with you, correct?
Y él actualmente vive con usted, ¿correcto?
Sí.
Yes.
And you filed this application because you believe that your son does not have the capacity to care for himself or manage his affairs.
Y usted ha interpuesto esa aplicación porque usted piensa que él no tiene la capacidad para poder cuidarse a sí mismo o de sus cosas.
Sí.
Yes.
And is his physician Dr. Richard Bang?
Y el doctor de él es el doctor Richard Bank.
Sí.
Yes.
And he's diagnosed your son with severe autism?
Y él ha sido diagnosticado con autismo severo.
Sí.
Yes.
Intellectual disability
Disabilidad intelectual
Sí.
and ADHD?
y déficit de atención.
And
¿Respuesta? Señora, ¿su respuesta?
Sí, así es.
Yes. Yes.
And Dr. Richard Bang has also told the court through his certificate that this conditions are not expected to improve, correct?
Y el doctor le ha dicho a este tribunal a través de su reporte que las condiciones de su hijo no van a mejorar, ¿correcto?
Sí.
Yes.
And you're asking the court to appoint your guardian of the person, correct?
Y usted le está pidiendo al tribunal que le interponga a usted como guardián de la persona, ¿correcto?
Sí.
Yes.
And your plan is to continue living in the same home with your son, correct?
Y usted tiene planeado continuar viviendo en el mismo hogar con su hijo, ¿correcto?
Sí.
Yes.
And you think that this is guardianship is necessary for you to take care of your son?
¿Y usted cree que esta aplicación es necesaria para que usted tenga cuidado de su hijo?
Sí.
Yes.
I'll pass it when it's running.
Yes,
Your Honor,
Betsy.
good afternoon, Judge. I don't have any questions of this witness. I will report to the court that I did meet. Well, I forgot the interpretation, Judge,
Su señoría, no tengo preguntas de este testigo,
but I do have a recommendation for the court.
sin embargo, tengo una recomendación para el tribunal.
Any other witnesses, Ms. Soto?
No, Your Honor.
Your Honor, I did review Dr. Bang's certificate of medical examination.
Su señoría, revisé el certificado médico y de la examinación
I did meet with Ms. Sepulveda and the proposed ward.
y tuve una junta con el pupilo propuesto y con la señora.
I do believe that the child needs a guardian of the person as recommended by Dr. Bang.
Y creo yo que él no necesita un guardián de la persona, así como fue recomendado por el doctor.
And I do believe that his mother is the appropriate person to do that.
Y creo que la madre es la persona apropiada para hacerlo.
So I do recommend that the court approve the application for guardian of the person by Ms. Sepulveda.
Y recomiendo que la aplicación sea otorgada a la señora Sepúlveda.
Anything else, Ms. Soto?
No, Your Honor.
I guess just one question for either or both, for purposes of the record.
Una pregunta para ambas o para alguna de ustedes para el propósito del récord.
Ms. Soto, Ms. Garcia, what if any other alternatives to guardianship have been explored and or discarded?
Judge, there isn't any least restrictive, Mr. Or the ward, Mr. Coronado cannot sign anything. His mental capacity is not there for him to understand any type of powers of attorney. And Dr. Bank's certificate confirms that.
¿Qué otras alternativas se han explorado además de esta aplicación para ser guardián de la persona que sean menos restrictivas? Su señoría, ¿no hay alguna otra condición menos restrictiva debido a que él no puede firmar ni tampoco puede comprender algún documento en el cual se le pueda ejercer poder sobre la persona?
Dr. Banks' certificate confirms that.
Y el certificado del doctor lo confirma.
And I concur with Ms. Soto's statement, Judge. There is no least restrictive alternative for this ward.
Y estoy de acuerdo con la abogada Soto, no hay algún otro método o manera menos restrictiva en cuanto a esta persona.
Ms. Sepúlveda, do you agree with everything that has been said?
Señora Sepúlveda, ¿está usted de acuerdo con todo lo que se ha dicho el día de hoy?
Sí.
Yes.
Does your son have any income whatsoever?
¿A su hijo tiene alguna manera o recibe algún tipo de dinero?
Sí,
Yes.
del Seguro Social por discapacidad y también por parte de su papá, child support.
Yes, through Social Security, due to being incapacitated, and through his dad, through child support.
Given that, Ms. Soto, what amount of bond do you believe would be reasonable and necessary in this case?
Your Honor, he's got minimal amounts of child support and minimal amounts of disability benefits, so may we request a $1,000 bond surety?
Debido a esa información, abogada Soto, ¿qué cree usted que sea un monto de fianza apropiado debido a los montos mínimos de manutención de menor o manutención de la persona? Y el Seguro Social estaremos pidiendo un monto de $1,000 bajo seguridad o firma.
Thoughts and opinion, Ms. Garcia?
I agree, Judge.
Opinión, señora o abogada García, estoy de acuerdo.
Anything the court should know as to any reasonable and necessary fees in this case, Ms. Garcia?
Your Honor, I requested $400 in attorney ad litem fees. Guardianships are certainly not the forum in which to overcharge folks who need to get a guardianship, and it's just the right thing to do, and she's paid.
¿Algún testimonio sobre los montos razonables por su trabajo, abogada García? Su señoría, $400 por mis servicios de abogada ad litem, debido a que en este tipo de aplicaciones, sobre todo por la necesidad de una persona que necesite ser guardián sobre otra, no es el lugar correcto para sobrecobrar. Y ella ya ha pagado el monto.
Ms. Sepúlveda, in your son's case, the court finds that it has jurisdiction.
Señora Sepúlveda, el tribunal halla que tiene jurisdicción sobre este asunto.
The court finds that your son is totally incapacitated,
El tribunal halla que su hijo está incapacitado de manera total.
cannot care for himself or manage his own property.
Puede cuidarse a sí mismo o puede manejar sus bienes.
The court finds that it is in your son's best interest to appoint a guardian.
Y el tribunal halla que está en el mejor interés de su hijo interponer un guardián.
And court finds that there are no other alternatives, certainly no other least restrictive alternatives to care for your son.
Y que no hay otro método menos restrictivo para poder cuidar a su hijo.
I find that you have complied with all of the requirements for the court to grant your request.
Hallo que usted ha cumplido con todos los requisitos para que se cumpla su petición
The court hereby appoints you as guardian of the person over your son.
y se interpone a usted como guardián de la persona.
Bond is hereby set at $1,000 as surety bond.
El tribunal interpone una fianza de $1,000 bajo seguridad
And the court also finds that your son is very fortunate to have you in his life.
y el tribunal halla que su hijo es afortunado de tenerle a usted en su vida.
Do you have any questions for the court, Ms. Sepúlveda?
Una pregunta para este tribunal, señora.
Pues espero que con todo el proceso que he llevado durante este año, ya pueda hacer yo poder tener la custodia de mi hijo, ya que desde que estoy embarazada siempre me he hecho yo a cargo de él solamente cuenta conmigo.
Well, I hope that through this whole process, I can have the full custody of my child. since I've been pregnant with him, he has been taken care of by me.
I have signed an order to that effect, and I am tendering the original to the clerk's office.
He firmado una orden que cause ese efecto y se le entrega la original a la Secretaría del Condado.
I wish both you and your son very well, and I will keep up with you every year as I read the reports in his case.
Solo mejor a usted y a su hijo, y estaré al pendiente de usted y de su hijo cada año que yo reciba y lea sus reportes.
Best wishes.
Gracias.
Thank you.
Thank you.
Council Soto standing in for Council Eduardo Romero on page 2, number 3.
This is in the estate of Alberto Luis Barakas, also known as Luis Alberto Barakas, cause number 2020 PB 795L2. Court marked Ms. Elisamar Soto, present in person. Are there any other lawyers, Bruce Warstack, or any other lawyers present on this case? I see Mr. Castillo is present. I believe he's the successor administrator. He's present in person. Isaura, Carolina Barajas, Jorge Alberto Barajas. Any other persons present on this case? Court finds no other persons are present. Ms. Soto?
Yes, Your Honor. Mr. Romero asked me to stand in for him and urge his motion to withdraw. It was properly filed and his client was notified, provided a copy of that motion and provided notice of today's hearing.
Mr. Castillo?
I don't have any objections, Judge, until the independent administrator.
I don't know that you know the answer to this question, Ms. Soto, but in review of this case, I was filed in, I guess, during the pandemic, 2020, and the court made some decisions a little bit over a year ago and set the orders due last summer, actually a year ago today, June 30th, 2025, but no orders have been filed. I don't know if maybe you know, Mr. Castillo, if the parties were considering filing those, or
I'm not certain, Judge, except that they did mediate about 45 days ago, more or less. They resolved all their issues. I will be following the instructions by the mediator and closing the estate pretty soon.
all right. So based on that, this is what the court's going to do. The court's going to grant the withdrawal. The court has signed an order effectuating that withdrawal. There is no objection. There is good cause, reason, and basis to do that. And now the court will sign an order setting this case to the inactive docket unless there's any other further request for relief filed by any party. So the court will prepare that order. Any thoughts or objections, Ms. Soto?
No, Your Honor.
Mr. Castillo?
No, Your Honor.
All right. Thank you both.
Page 8, number 29.
Page 8, number 20.
Yes.
Ricardo Cavasos versus Juan Antonio Ayala, cause number 2024 CVG 1428C3. Court marks Ms. Elisamar Soto present in person on behalf of Mr. Romero. Mr. Guadalupe Castillo is also present in person. Ricardo Cavasos, Juan Antonio Ayala. Any parties present? Court finds no parties present. Counsel, what is the announcement?
Your Honor, this is also a motion to withdraw. Mr. Romero advised he did present this copy of the motion to the parties. He represents the plaintiffs in this matter and advised them of this court setting if they wanted to come and object, and he received no response. So we are asking the court to grant that withdrawal.
Mr. Castillo?
I don't have any objection to the motion filed by Mr. Romero, Judge.
All right, so let's do 2 or 3 things. There being no objection, the court is granting the request. The court finds there is good cause, reason, and basis to do so. The court is tendering that original signed order to the clerk's office. So Withdrawal has been granted. Second thing the court is going to do, the court is going to instruct court staff to add in the email addresses provided by Mr. Romero in his service of the motion to his former clients on the e-service list so that they have notice, so that Mr. Romero gets substituted in for the parties, the now self-represented parties in this case. Court staff will add those emails to the service list. And the third and last thing, Mr. Castillo, this is a docket control conference. So I need to set some deadlines. Is this going to be a jury trial or a bench trial?
We had set it down as a jury trial, Judge, but I don't
A
think,
little closer to the mic, please.
I don't think the jury fee was paid, Judge, and I don't object to a bench trial.
Was the jury trial requested by Mr. Romero or by your client?
I believe it was my client, Judge.
Okay,
He appeared first, we sought an attorney and then he hired me, and so
if this is going to be a bench trial, when would you like that trial set in 30, 60, 90 more?
I would think about 90 days, Judge. I envision filing a motion for summary judgments.
All right. Ms. Rodriguez, give us, you said 60, right?
90 days.
90, sorry. Ms., this is why I was thinking 60. Ms. Rodriguez, give us a setting for a bench trial in 90 days. So early October, late September?
October the 6th at 2 p.m.
And give us a final pretrial hearing in early September, give or take a few weeks.
September 15th at 2 p.m.
Any objection to these dates, Mr. Castillo?
The October 6th is fine, Judge. September 5,
15.
15 is fine. They're fine, Judge, both
All right.
days. Yeah.
All right, we will hold a bench trial and final pretrial hearings on those days. All right, thank you both.
Your Honor, may I ask a question?
Yes,
The jury trial had been postponed because they were going to mediation. Did that take place in February?
Yes, mediation did take place, Judge. The parties did not settle the matter.
all right, well taken. Any other cases for either?
Just the one on recall for Ms. Soto?
Any other cases for Mr. Castillo?
None for Ms. Castillo.
Good to see you, Mr. Castillo. Have a great day.
Next in person is Counsel Cavasos, page 8, number 19.
To the estate of Hime Ramirez, cause number 2026 PB 933L2. Court marks Mr. Cavasos present in person. Good afternoon, counsel.
Good afternoon, Judge.
Speak into the microphone and tell the court, are you Berta Alicia Ramirez?
Sí, señor. She's gonna need an interpreter.
Habla ante el micrófono, ¿es usted Berta Alicia Ramírez?
Sí, señor.
Yes, sir.
Welcome to court. You're in person.
Bienvenida al tribunal, está usted en persona.
Person to your right is your lawyer.
La persona a su derecha es su abogado.
Announcement, Mr. Cavasos.
Judge, I was just gonna ask her some questions to prove up the minimum of title.
Su señoría, le haré unas preguntas a mi cliente para comprobar nuestro caso.
Ms. Ramirez, would you raise your right hand?
Ramírez, por favor, levante su mano derecha.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Jura o afirma que el testimonio que dará ante el día de hoy es la verdad, toda la verdad, bajo el amparo de Dios?
Sí, señorita.
Yes, Your Honor.
You may lower your hand, Mr. Cavasos.
Judge, before we get started, I'd ask the court to take judicial notice that the purported will of decedent was filed in the matter is in fact an original document.
Su señoría estaré pidiéndole al tribunal que tome notificación judicial que el testamento archivado es una copia original.
Notice so taken.
Así se toma la notificación.
Thank you, Your Honor. Ms. Ramirez, will you please state your name for the record?
Señora Ramírez, por favor, diga su nombre para el récord.
Berta Alicia Ramirez.
Berta Alicia Ramírez.
Did Jaime Ramirez decedent die on August 27, 23 in Laredo, Webb County, Texas, at the age of 49.
El fallecido Jaime Ramírez falleció en el condado de Webb a la edad de 49 años el día 27 de agosto del 2023.
Sí, señoría.
Yes, Your Honor.
I showed you earlier today, his last will. Do you recognize that to be the will of Jaime Ramirez, the one that was dated December the 8th, 2022?
Le mostré a usted un documento. ¿Usted reconoce este documento como el último testamento fechado 8 de diciembre de 2022?
Sí, señoría.
Yes, Your Honor.
And was deceased at least 18 years of age and of sound mind at the time of the execution of the will.
Y el ya fallecido era mayor de edad y tenía mente clara cuando efectuó este testamento.
Sí, señoría.
Yes.
Did the decedent revoke the will?
¿El fallecido revocó este testamento?
No, señor.
No.
Have 4 years elapsed since the date of decedent's death and the filing of the application to probate his decedent's will?
Han pasado 4 años desde el fallecimiento del señor y que se haya interpuesto este caso ante el tribunal.
No, señor.
No.
Was decedent a resident of and have a domicile or fixed place of residency in Webb County, Texas?
El fallecido vivía y tenía una residencia fija en el condado de Webb, Laredo, Texas.
Sí, señor.
Yes.
Were any children born or adopted by decedent after the execution of the will?
¿Algún menor nació o fue adoptado por el ya fallecido antes de que se ejecutara el testamento?
No, señor.
No.
Were any of decedent's marriage dissolved after the execution of the will?
¿Algún matrimonio fue disuelto después de la ejecución de el testamento del ya fallecido?
No.
No.
Is any state, governmental agency, or charitable organization named as a devisee in the will?
¿Alguna entidad del Estado o alguna organización de caridad son mencionadas en el testamento?
No.
No.
Did decedent receive Medicaid benefits on or after March the 1st, 2005?
No.
¿El fallecido recibió algún tipo de servicio de parte de Medicaid después del 1 de marzo del 2005?
No.
No.
Does decedent estate owe any unpaid debt other than any debt secured by lien on real estate?
¿El fallecido tenía algún adeudo okay. My apologies.
Does decedent estate owe any unpaid debts other than a debt secured by a lien on real estate, like a mortgage?
¿El fallecido tenía algún otro adeudo, además de algún tipo de adeudo, como digamos alguna hipoteca sobre sus bienes?
No.
No.
Judge, that's all I have, and I'm asking the court to sign the order. I think I provided the order.
Su señoría, es todo lo que tengo por medio de este testimonio. Le pedimos al tribunal que firme la orden que creo yo archivé.
Ms. Ramirez, in the case of your husband, the court finds that it has jurisdiction,
Señora Ramírez, en el caso de su esposo, el tribunal halla que tiene jurisdicción sobre este asunto,
meaning this is the correct forum and venue to consider your request.
lo que significa que este es el tribunal adecuado y la manera adecuada para considerar su petición.
The court takes judicial notice of the entire case file, including your husband's original will,
El tribunal toma notificación judicial del archivo entero, incluyendo el testamento original,
his original death certificate,
su certificado de fallecimiento original
and the citation by posting.
y el citatorio.
The court finds that unfortunately your husband passed away on the 27th day of August, 2023 at the age of 49.
El tribunal halla que desafortunadamente su esposo falleció el día 27 de agosto de 2023 a la edad de 49 años
Having left a signed, valid, executed, and unrevoked will.
y dejó detrás un testamento firmado y sin revocar.
The court finds that no children were born adopted after the execution of that will.
El tribunal halla que ningún hijo nació después o fue adoptado después de la ejecución de este testamento
The court finds that no marriages were dissolved either after its execution.
y que ningún matrimonio fue disuelto después de que se ejecutó.
The court finds that your husband did not name the state of Texas, any state, or any charitable organization as devisees.
Y que no mencionó en ese testamento ninguna entidad estatal o ninguna caridad.
The court finds that you are entitled to the request you are making. The court hereby grants your request and admits your husband's will into probate as muniment of title.
Y el tribunal halla que usted tiene derecho a su petición e adopta ese testamento.
The court has signed an order to that effect and is tendering the original to the clerk's office.
El tribunal está firmando la orden y se le entrega la original a la Secretaría del Condado.
Mr. Ramirez, do you have any questions for the court?
¿Alguna pregunta para el tribunal, señor?
No, señoría.
No, Your Honor.
I wish you very well and you have the court's condolences.
Seamos lo mejor y le damos nuestro pésame. Good. Thank you.
Any other cases for Mr. Cavasos?
No, Your Honor.
No.
It's good to see you, counsel.
Likewise, Judge.
Have a
Thank you
great
very
day.
much.
Some person is counsel Ernnandez Garcia, page 2, number 4.
This is the estate of Alejandro Evaristo Villarreal III, cause number 2021 PB 555L2. Court marks Ms. Garcia present in person. Mr. Tamés is present in person. Juan Ernnandez, are you present? Court finds Mr. Ernnandez not present. Roberto Villarreal, Fernando Villarreal, any parties present?
Yes, Your Honor. Your Honor, for the record, Francisco Tamés, I represent Fernando Villarreal and the co-applicant Javier Villarreal are in the courtroom.
You said Fernando Villarreal and Javier Villarreal?
Correct.
Court will mark those persons as present in person. Roberto Rodriguez, any other person present?
Your Honor, I represented Roberto Rodriguez, who is still the court-appointed dependent administrator. I filed an advisory to the court a couple of months ago advising that I believe that Mr. Rodriguez is non-compos mentis and unable to continue with his duties. I've conferred with all of the counsel for all the heirs of the estate and advised them that a new administrator must be appointed. I will report to the court that the parties have come to an agreement. The heirs have come to an agreement. A family settlement agreement is prepared, awaiting execution, but they've already relied on their agreements and started performing on those agreements, Judge. It just needs to be signed, and the only things left for an administrator to do is to sign all the documents in order to partition and distribute the estate's assets pursuant to the heirs' agreements, Judge. And so I understand that Mr. Fernando Villarreal and Mr. Javier Villarreal have filed an application for appointment of successor administrator, Judge. So I'm here. I really don't have authority for anybody. So I'm just here to provide the court information, Judge, and that's what is going on.
Mr. Tamés.
You're correct, Your Honor. So the three heirs, now that certain one party has been, the issues with one party have been resolved, are the three sons of Alex Villarreal. Two of them are here. They're the joint applicants to succeed as dependent administrators. And so what the three brothers did is we actually entered into a mediated settlement agreement January of last year. And it has been revised since then, but the parties have partially performed. I think for the most part, it's just a issue of executing, like Ms. Lanessa Garcia said, the documents necessary to transfer. That's about it. But there is a settlement agreement between the parties. I'm asking that my client, Fernando Villarreal, serve in that successor administrator, dependent administrator for all practical purposes of what's left, that a minimum surety bond be issued by the court, and that we can hopefully tie everything up with the next couple of months. The brothers have already divided the largest asset, which was 2 companies and 1 tract of land with 2 lots. And that was really, I think, the most pressing issue for the lawyers that were papering this up and getting that performed. So really, right now, it's all a question of just execution of those documents.
How much time would be reasonable and necessary to execute those documents?
I think Ms. Lanessa Garcia, to her credit, has prepared a lot of those. And so
I know that a couple of one deed has been prepared. I don't recall if I prepared, there have to be assignments of partnership interests and limited liability company interests. And that's it.
Well, let me ask you this, because
And
ostensibly
one deed.
all
Sorry.
of those documents would be covered by the MSA. So let me ask you this, how soon would you like a setting for either that to finalize like a final hearing or an entry of judgment? Because all I need to do, all the court needs to do is sign an order effectuating the MSA, and all of that just becomes obligatory. All the document preparation then becomes obligatory. So how soon would you like either that final hearing or entry of judgment date?
I would, in a couple of weeks, and like I said, I prepared and circulated a family settlement agreement to incorporate the last of the agreements that they made, so it's comprehensive. And with all the recitals necessary for the court to accept into the court's record. So I would ask that the
2 to 4
heirs
weeks.
execute that by a date certain and file it into the court. So 2 weeks would be ideal, because this has been pending for a very long time. They finally came to an agreement, and so we just want to close it out.
All right, so I'm gonna push this on, understanding that it's not gonna be a contested matter, but rather it's just gonna effectuate the parties' agreement, or at least that's what the court's going to do. I'm gonna schedule this for July 16th at 9 a.m. Thoughts, comments, objections, Ms. Garcia,
I think that's great, Judge.
Mr. Temes?
No, Judge, and that should be for the, I guess, the court approving the MSA, the family settlement agreement and entry of a judgment.
And ordering the successor administrator to
Perform.
perform the duties and execute all the documents to partition
Yeah,
and
absolutely.
distribute the
And
assets.
I think as long as we can get, so yes, I agree. But for purposes of at least appointing somebody now, I think we can get the ball rolling on that. And so I think the next step, Judge, if we could, I'm willing to have Mr. Villarreal, go under oath and let's see if we can get him approved by the court to fit that role.
As a
Successor, dependent administrator. Because that person is the one who is going to actually have to execute these documents on behalf of the estate to transfer those interests, those properties pursuant to the MSA and then the family settlement agreement. It's limited, I know. And it was just,
Yeah.
By pure, bad luck that Ms. Lanessa Garcia fell into that issue where she had no authority. And we didn't have anybody that had the mental capacity to execute those documents. And she tried. I know that she tried.
It's not going to have someone that I believe was non-compos mentis sign a document just to get it done. So
Your Honor,
report to the court.
Your Honor, Guillermo Garcia here. I represent the third heir, Alejandro Villarreal the fourth. I've been present the entire time, Judge. If I understood the court correctly, though, you were just going to approve the MSA and then the parties were going to have to execute the documents. Was that the court's intention without having to appoint anybody?
Initially, and then I heard from Mr. Temes about the possible necessity to take some action today. So I'm now rethinking my initial thought. What, Mr. Garcia, are you making an informal appearance on behalf of? Tell me the name of the party again.
Alejandro Villarreal the fourth.
The fourth. And Mr. Garcia, what say you on any or all of this?
Your Honor, initially, I think all the brothers wanted to be the one appointed to do this, and that's why we couldn't come to an agreement. And I think the way Your Honor posed it right now was, I think, workable in the sense where the court ordered this is what it was going to be, and then we have to execute the documents. It accomplishes, nobody gets appointed, and we just do what needs to get done. But we've been sorry.
I guess I misunderstood. Mr. Garcia, was your client a signatory or an authorized person or somehow involved in the mediated settlement agreement?
Yes, Judge, he was a party to it. One of the heirs.
There's 3 sons.
And as part of that mediated settlement agreement, has one person been designated as the dependent administrator?
No,
No.
sir.
There was already an individual named in the last will, or that was actually not in the last will and testament. That was named to be the administrator, which was Ms. Lanes's client, but he is now no longer competent and able to proceed to execute all the documents of an administrator. And so we're left with that last final step before he could execute, Judge. And I think the attorneys were coming to the court is to have somebody appointed that can take us across that finish line and resolve this. And so what I think Mr. Tames was asking for is for somebody to be appointed now over the next 2 weeks and accomplish those goals. And if I understood the court was gonna just approve the MSA and then have the parties execute the documents because it was pro forma after the court had already ordered it.
In a very roundabout way, that's exactly, you've summarized it very, very well. And in hearing Mr. Tames, I'm wondering whether if the court appoints no one, then nobody becomes responsible for this. Thoughts, comments, Mr.
Judge, we need someone.
Yeah.
There needs to be someone to sign a deed.
Yeah.
There needs to be
Right.
someone to sign assignments of partnership interests.
So
We
that-
do need a successor administrator.
I would assume that that's exactly where we were heading, and that's that was the intention of setting something for July the 16th. Well, let me ask this, Mr. Garcia, any objection to the court hearing testimony today?
No objection, Judge.
Huh? And are you Fernando Villarreal? Would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes.
You may lower your hand. Mr. Tames.
Mr. Villarreal, can you please state the full name for the record?
Fernando Francisco Villarreal.
And Mr. Villarreal, you have two brothers who are the last legal heirs of Alejandro Evaristo Villarreal III, is that correct?
Correct.
And Alejandro Evaristo Villarreal was your father?
Correct.
Alex Villarreal?
Yes.
And the three heirs are your two brothers, correct?
Correct.
So the only heirs before the court in this heirship, in this administration, are yourself and your two brothers, correct?
Correct.
And you and your brothers have reached a mediated settlement agreement, which the parties already partially performed, correct?
Correct.
And at this point, the administration or the estate needs to execute certain documents to transfer those properties pursuant to that mediated settlement agreement, correct?
Correct.
Mr. Villarreal, standing to your right is your brother Javier Villarreal, correct?
Correct.
And Javier Villarreal, to the best of your knowledge, agrees that you should serve as the successor dependent administrator, correct?
Correct.
Mr. Villarreal, you've never been convicted of a crime involving fraud or moral turpitude, is that correct?
That's correct.
You have no claims against your father's estate.
No.
You're not disqualified from serving as the administrator of your father's estate, correct?
Correct.
And you're willing to execute your duties as successor dependent administrator in order to effectuate the signing of these documents. That's all that's required to close out the estate, correct?
Correct.
You're willing to post bond?
Yes.
Okay. And in terms of the administration of the businesses, you're well familiar with the accounts, the property that's in the estate that remains to be transferred and conveyed. Is that correct?
Correct.
No further questions, right?
Mr. Garcia, any questions for Mr. Fernando Villarreal?
No questions, Joe.
All right. Request, Mr. Tames.
Your Honor, I asked that the court grant the joint application that was filed by two of the three brothers. They're in agreement that Fernando Villarreal, my client, serve as the dependent administrator, successor administrator, in order to effectuate just the signing of these documents and close out this estate.
Request or objections or both, Mr. Garcia?
None, Your Honor.
All right. Court finds that it has continued jurisdiction over this matter. The court takes judicial notice of the entire case file. The court has now had the benefit of counsel argument and Mr. Fernando Villarreal's testimony. The court hereby approves the joint application. The court hereby appoints Mr. Fernando Villarreal as the dependent successor administrator. The court will set a bond in the same amount as the former dependent administrator, unless there is an objection that the court will entertain. Ms. Garcia?
Just for informational purposes, Judge, that was a $5,000 surety bond.
All right, Mr. Garcia,
No objections, Judge.
Mr. Tames?
No, Judge, I think that'd be fine. I think we could get those, that filed it as quickly as possible in order to push this across the finish line.
All right, the court takes the request as well taken, grants it in full. The orders of the court are due on or before that next hearing date, which is the execution. Unless there's no longer a necessity for that, is there? No, that for the July 16th hearing at this point, because now
Just my 2 cents. I would still like a deadline for that family settlement agreement to be signed by everyone, just to avoid problems.
all right, well, let's come back then for entry of judgment on July 16th at 9 a.m. The court will resolve any pending issues if there are any. Mr. Fernando Villarreal, do you have any questions for the court?
No.
Mr. Javier Villarreal, do you have any questions?
Oh, yeah.
Anything else, Ms. Garcia?
Again, I'm operating without authority. I'm just providing my 2 cents, given my familiarity and involvement in representing the former dependent.
Court
administrator.
appreciates the procedural history and knowledge. Mr. Garcia, anything else on this case?
Nothing further, Judge.
Mr. Tames?
Nothing further, Your Honor.
Good luck to all. We'll
Thank
see you
you,
on the
sir.
17th.
Thank you.
Next case for counsel, Vanessa Garcia, page 7, number 18.
To the estate. I'm sorry. Go ahead.
Cases for counsel Tames or counsel Guillermo Garcia.
Mr. Tames, Mr. Garcia, good to see you both. Have a great day. Page 7, case 18, the estate of Adolfo Garza, cause number 2026, PB 737L2. Court marks Ms. Vanessa Garcia present in person. Julian Garza. Very good, thank you. Speaking to the microphone and tell the court, are you Julian Garza?
Yes, sir.
Welcome to court. The court marked you present in person. Ms. Garcia, what is the announcement?
Your Honor, this is an application to probate a holographic will, Judge. And so I have my client, Julian Garza, who's going to give, he's the applicant judge. He was the named executor in the will. And then I have 2 witnesses here to testify to verify the authenticity of the decedent's handwriting, and that is Mr. Manuel Garza and Miss Maria Garza, all 3 of whom are going to require interpretation, Judge.
And the other persons joining Manuel and
The other
Maria Garza?
persons, Marta Garza, who is a beneficiary, and her son, who's here for support of the family support, Judge. And your name? Jesus Dominguez. And Marta Dominguez, I apologize. Marta Garza, I'm just fumbling it up. Thank you.
I tell you what, you are fine where you're at, Mr. Garza, Mr. Julian Garza. Manuel and Maria Garza, please step in front of this microphone, and everybody else step up. Yes, that's exactly right. You need to be in front of the camera just in case somebody requests a transcript. We have a good video feed as well. Mr. Julian and Manuel Garza and Miss Maria Garza, would you all raise your right hands?
Por favor, levanten su mano derecha.
Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Por afirmar que el testimonio que darán del día de hoy será la verdad bajo el amparo de Dios.
Yes, sir.
Yes, yes. You also need to interpret?
Yes.
Yes.
Court has heard yes from all. You may lower your hands 1 witness at a time. Ms. Garcia, go ahead.
I will begin with Mr. Julian Garza, the applicant. Mr. Garza, is your full name Julian Garza?
Correct. Correct.
Señor, ¿su nombre completo es Julián Garza?
Correct.
It is correct.
Are you the applicant in this matter?
¿Es usted la persona que aplicó en este asunto?
Correct.
Correct.
And you are asking the court to probate a holographic or handwritten will signed by your brother Adolfo Garza.
Usted le está pidiendo a su tribunal que apruebe un testamento holográfico o uno escrito a mano de su hermano Adolfo Garza.
Es correcto.
Correct.
And Adolfo Garza died on April 16th, 2026 in Laredo, Texas, correct?
Y Adolfo Garza falleció el día 16 de abril del 2026, ¿correcto?
Correcto.
Correct.
And when he died, he was 55 years old, residing in Laredo, correct?
Y cuando él falleció, él tenía la edad de 55 años y vivía en la ciudad de Laredo, ¿correcto?
Correcto.
Correct.
And his estate consists of real property and personal property, correct?
Y los bienes de él consisten en bienes raíces y propiedad personal, ¿correcto?
Es correcto.
Correct.
And during the last days of his life, he wrote out a holographic will, correct? A handwritten will?
Y durante sus últimos días de vida, él escribió a mano, puño y letra, un testamento, ¿correcto?
Es correcto.
Correct.
And that will is dated April 10th, 2026, correct?
Y ese testamento está fechado día 10 de abril del 2026, ¿correcto?
Correcto.
Correct.
And that will was never revoked, correct?
Y ese testamento nunca fue revocado, ¿correcto?
Correcto.
Correct.
And the will was written entirely in his handwriting, correct?
Y este testamento fue escrito totalmente en su puño y letra.
Correcto.
Correct.
Now, it's not very legible because he was sick at the time, correct?
Ahora, no es muy legible debido a que él estaba enfermo, ¿correcto?
Es correcto.
Correct.
And he had physical issues trying to write it, correct?
Además de que tuvo problemas físicos para escribirlo, ¿correcto?
Correcto.
Correct.
So someone who's familiar with his handwriting can read what it says specifically, correct?
Así que alguien que está familiarizado con la letra de él podría leerlo.
Es correcto.
Correct.
So it's better to have an administration of the estate instead of filing it as a muniment of title, correct?
Así que es mejor interponer una administración de estos bienes, ¿correcto?
Correcto.
Correct.
That way someone can properly interpret it and effectuate your brother's wishes, correct?
Así que de esta manera se puede interpretar de manera correcta los deseos de su hermano, ¿correcto?
Es correcto.
Correct.
And in that handwritten will, he did name you as executor, correct?
Y en ese testamento de puño y letra, él le interpuso a usted como ejecutor de sus bienes, ¿correcto?
Es correcto.
Correct.
And you and your sister Marta are the beneficiaries of his estate, correct?
Y usted y su hermana Marta son las personas beneficiadas de estos bienes, ¿correcto?
Correcto.
Correct.
And also Jesus, correct?
Además de Jesús.
Correcto.
Correct.
And all three have signed consents, not only waivers of service, but consents for you to serve as an independent administrator, correct?
Y todos ustedes tres han firmado consentimientos y además de renuncias a los citatorios formales para que usted sirva como administrador.
Es correcto.
Correct.
And after your brother signed his will, he didn't have any children born or adopted, correct?
Y después de que él firmó su testamento, él no tuvo algún hijo o ninguno fue adoptado, ¿correcto?
Correcto.
Correct.
And your brother was in fact never married before, correct?
Y su hermano, de hecho, nunca estuvo casado.
Correcto.
Correct.
And there's no government agency or charitable organization named as a beneficiary in his handwritten will, correct?
Y no hay entidad gubernamental ni caridad mencionado en el testamento, ¿correcto?
Es correcto.
Correct.
And you have asked your brother Manuel and your sister Maria to testify and sign affidavits regarding the authenticity of your brother's will, correct?
Y usted le ha pedido a su hermano Manuel y a su hermana María que testifiquen el día de hoy y además de que interpongan declaraciones juradas en cuanto a el testamento, ¿correcto?
Correcto.
Correct.
And they're here to testify, correct?
Y están aquí para testificar, ¿correcto?
Correcto.
Correct.
And you're asking the court to probate your brother's handwritten will
Y usted le está pidiendo al tribunal que acepte el testamento de su hermano a puño y letra.
Correcto.
Correct.
and to appoint you as independent executor, correct?
Y que se le interponga a usted como administrador independiente, ¿correcto?
Correcto.
Correct.
Those are all the questions I have for Mr. Garza, Judge.
Next witness.
Next witness is Manuel Garza. Mr. Garza, is your full name Manuel Garza?
Señor, ¿su nombre completo es Manuel Garza?
Sí.
Yes.
And Adolfo was your brother, correct?
Y Adolfo era hermano de usted, ¿correcto?
Correcto.
Correct.
Did you see the handwritten will that Adolfo wrote?
¿Usted vio el testamento escrito en puño y letra de que su hermano Adolfo escribió?
Sí,
Yes.
Were you able to examine it?
¿Usted tuvo la oportunidad de examinarlo?
sí,
Yes.
Is that will written completely in your brother's handwriting?
Ese testamento está escrito de manera total de puño y letra de su hermano?
sí,
Yes.
And does it contain his signature?
¿Y contiene la firma de él?
sí.
Yes.
And how are you familiar with his handwriting, if you can explain that to the court?
¿Y cómo está usted familiarizado con la letra de su hermano?
Pues sí estoy familiarizado.
I am familiarized.
¿Le puede explicar a la corte cómo conoce? I'm sorry. Can you explain to the court how you are familiar with your brother's handwriting?
¿Le puede explicar al tribunal cómo es que usted familiarizado con la letra de su hermano?
Pues es toda una vida de hermanos. Obviamente me tocó vivir muy de cerca con él, conocer su letra. Todos de alguna forma somos unidos y nos conocemos perfectamente.
I spent a whole lifetime with him as siblings. And you could say that we lived a life together. And I know his handwriting. We are a very united family.
Thank you. I have no more questions for Manuel Garza.
Your next witness.
Maria Garza? Ms. Garza, is your full name Maria Garza?
Señora
así
Garza,
es.
¿su nombre completo es María Garza?
Sí, así es.
Yes, yes.
And were you able to take a look at Adolfo's handwritten will?
¿Y usted pudo ver el testamento de puño y letra de su hermano?
Sí, sí lo
Yes.
pude ver.
Yes, I could see it.
And are you familiar with Adolfo's handwriting?
¿Usted
Sí,
está familiarizada con la letra de su hermano?
Sí, totalmente.
Yes, totally.
Can you explain to the court how you're familiar with his handwriting?
¿Y usted le podría explicar al tribunal cómo es que usted conoce la letra de su hermano?
Porque tenemos toda una vida, como dijo mi hermano Manuel, viviendo juntos. Tengo cartas de él, vi siempre sus documentos, vi sus documentos de trabajo, sus documentos de escuela. Todos estamos familiarizados con toda una vida viéndolo escribir.
Because we have lived a life together, just like my brother Manuel mentioned. I have letters from my brother. I was able to observe and see documents from his job, documents from school. Like my brother said, we have lived a life together.
Do you believe that your brother's handwritten will is written fully in his handwriting?
¿Usted cree que el testamento de puño y letra de su hermano está escrito en su totalidad bajo la letra de su hermano?
Sí, lo creo,
Yes, I believe it
porque yo lo vi.
because I saw it.
Did you see him write that whole will?
¿Usted lo vio a él escribir ese testamento en su totalidad?
Sí, de principio a fin.
Yes, from beginning to end.
And do you believe he had capacity to do so?
¿Y usted cree que él tenía la capacidad mental de hacerlo?
Sí, sí
Yes,
la tenía.
yes, he had it.
Thank you. Your Honor, at this time, I would ask the court to take judicial notice of all the materials on file, including the waivers of service and the consents for independent administration judge. For my client to act as an independent executor as the will is silent with regard to that. I ask the court to find that the holographic will is in fact written completely 100% in the handwriting of the decedent, the testator, and that it is in fact his original handwritten will, that the court probate that will. At this time, appoint Mr. Julian Garza as independent executor judge and issue letters testamentary to him. And with regard to the bond, again, the will is silent with regard to that. But I believe that the two beneficiaries here will agree that Mr. Garza should perform his duties without bond or a very minimal bond.
Mr. Garza and Ms. Garza, in your brother's case, the court finds that it has jurisdiction.
Señores, señora, en este caso, el tribunal halla que tiene jurisdicción sobre este asunto.
The court hereby takes judicial notice of the entire case file,
El tribunal toma notificación judicial del archivo entero,
which includes your brother's original death certificate,
el cual incluye el certificado de fallecimiento original,
the citation by posting,
los citatorios,
the consent of the distributees,
el consentimiento escrito,
and your brother's holographic will.
además del testamento de puño y letra de su hermano.
The court finds that your brother unfortunately passed away on the 16th day of April, 2026 at the age of 55.
Vaya que lamentablemente su hermano falleció el día 16 de abril del 2026 a la edad de 55 años.
Having written this will, this document that he purport to be his will dated April 10th, 2026.
Y haya que el testamento fechado 10 de abril del 2026,
The court has heard the testimony of both Mr. Manuel Garza and Maria Garza,
tribunal habiendo escuchado el testimonio del señor Manuel y la señora María Garza,
having been fully familiar with his penmanship, handwriting, and signature. The court finds that this document was in fact written by him and signed by him.
el tribunal habiendo escuchado que ambos habían sido familiares con la letra y con la firma de él, haya que este documento fue escrito y firmado por el fallecido.
Clearly and apparent to the court, not only with a lifetime of life, but also of love.
Es claro para este tribunal que no solamente debido a la familiarización o la familiaridad debido a una vida vivida juntos, sin embargo, el amor entre todos.
The court finds that the will was executed, never revoked.
Este tribunal halla que este testamento fue ejecutado y nunca fue revocado.
The court finds that Mr. Julián Garza should be and is hereby appointed as the independent executor.
Y este tribunal halla que el señor Julián Garza debe de ser interpuesto como el administrador independiente
Therefore, the court hereby admits that document into probate,
y se admite este documento al legajo de ley testamentaria.
appoints Mr. Garza as the independent executor,
Se interpone al señor Julián Garza como el administrador independiente
and the court will cause letters to be issued out to you.
y se le otorgan los datos de administración.
You're to serve without bond.
Usted va a servir sin fianza alguna.
The court hereby tenders the original signed orders to the clerk's office,
Que otorga la orden firmada a la Secretaría del Condado.
Mr. Garza, the inventory on your brother's case is due on or before September the 17th at 9 a.m.
Señor Garza, el inventario de los bienes de su hermano deberá de ser entregado antes o el día 17 de septiembre a las 9 de la mañana.
Mr. Garza, do you have any questions for the court? Mr. Manuel Garza, do you have any questions?
Manuel Garza?
No.
No, thank you.
Maria Garza,
No. Thank you very much. No,
Marta Jesus Domingos, do you have any questions?
no, thank you.
Court has heard no from all. You have the court's most sincerest condolences.
Thank you, Judge.
Yes. Thank you.
Any other cases for Ms. Garcia?
No, Your Honor.
Thank you, may be excused.
Have a great day.
Next in person, Council Maddox, page 5, number 11.
This is in the estate of Joanne K, cause number 2025 PB 783L2. Court marks Mr. Maddox present in person. Gregory Can, are you present?
Good afternoon.
Good afternoon, Mr. Maddox. Good to see you. Speaking to the microphone and tell the court, are you Gregory Can?
Yes, I am.
Welcome to court, Mr. Can. The court marks you present in person. The person to your right is your lawyer, Mr. Maddox. What is the announcement? Into the record?
To prove up the admission of a will to probate and granting of letters testamentary for an independent executive.
Mr. Can, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God? Court has heard yes. You may lower your hand. Let me just ask court staff, was that loud enough?
Yes, Your Honor.
Very good. Mr. Maddox.
Yes, Your Honor, I'd ask the court to take judicial notice of the purported will of the decedent and death certificate that were, the originals were filed.
Notice so taken.
Thank you, Your Honor. Could you please state your name for the court?
Gregory Can.
And did your mother, Joanne Can, who we'll refer to as decedent, die on October 25th, 2025?
Yes.
In Laredo, Webb County, Texas, at the age of 83?
Yes.
And was she at least 18 years of age and of sound mind at the time she executed the will?
Yes.
And do you recognize the will that was attached to the application to be the last will of Joanne K?
Yes.
Did she ever revoke the will?
No.
Have 4 years passed since her death and the filing of this application?
No.
And was she a resident and have a fixed domicile here in Webb County?
Yes.
And after the execution of the will that was offered, did she have any children born or adopted?
No.
And after the will was executed, were any of her marriages dissolved?
No.
Is any state governmental agency or charitable organization named as a devotee in the will?
No.
And did she receive any Medicaid benefits on or after March 1st, 2005?
No.
And you're named in that will as the independent executor of her estate to serve without bond?
Yes.
And are you aware of any reason that you're not qualified by law from accepting that appointment and letters testamentary?
No.
Have you ever been convicted of a crime of theft, fraud, or any type of moral turpitude?
No.
Is there any other reason you should not be appointed as the independent executor?
No.
And do you request that the court admit the will into probate, issue you letters testamentary as a independent executor, and to serve without bond as provided in the will?
Yes.
Thank you, Your Honor. I would just ask the court to take judicial notice that the return is on file, and I have filed a proposed order admitting the will, and I would ask the court admit it to probate, grant letters testamentary.
Mr. Can, in your mother's case, cause number 2025 PB 78302, the court hereby finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider admitting your mother's will into probate. The court hereby takes judicial notice of the entire case file, which includes your mother's original death certificate, her original will, and the citation by posting. The court finds that unfortunately your mother passed away on the 25th day of October 2025 at the age of 83. The court finds that she in fact executed a will that was never revoked, changed, or modified, and that was executed on March the 4th, 2016. The court finds that pursuant to her will, she did not name the state of Texas or any other state or any charitable organization as devisees. No marriage was dissolved, neither did she have any children, or none were adopted after the execution of that will. The court finds that you are named in that will to serve in this capacity. The court finds that you are qualified and you are not disqualified from serving. For all of these reasons, the court hereby grants your request, admits your mother's will into probate, appoints you independent executor. You are to serve without bond, and the court will cause letters of testamentary to be issued out to you. The court is tendering an original signed order, granting all of this to the clerk's office, and the inventory on your mother's case is due on or before September 17th at 9 a.m.
Thought that was a special one for me.
September 17th at 9 a.m. Yes, please. Mr. Cannon, the court has granted your request in full. Do you have any questions for the court?
No. Thank you, Your Honor.
You have the court's sincere condolences, and I wish you well.
Thank you, Your Honor.
Any other cases for Mr. Maddox?
Page 6, number 13.
This is the estate of Ramona Ernnandez, cause number 2025 PB 962L2. Court marks Mr. Maddox present in person. Matilde Trevino, if you're present, please step forward. Valeriano Hernandez Jr., Silva Ramos, San Juanita, San Miguel, Ernestina Trevino. If there are any other persons present, please step forward. Speaking to the microphone and tell the court, are you Matilde Trevino?
Yes, Your Honor.
Welcome to court, Ms. Trevino. The court marks you present in person. The person to your right is your lawyer. Speak as loud as you can and tell the court your name, please.
Matilde Trevino.
San Juanita, San Miguel.
Ms. San Miguel, welcome to court. The court marks you present in person.
Ernestina Trevino.
Ms. Ernestina Trevino, welcome to court. The court marks you present in person.
Silvia Ramos.
Ms. Ramos, welcome to court. The court marks you present in person.
Valeriano Hernandez Jr.
Mr. Hernandez Jr., welcome to court. The court marks you present in person. Mr. Maddox.
Yes, Your Honor, I would like to prove up this will as a muniment of title. I'm gonna take the entire prove up with Ms. Trevino, and then I was gonna do a brief summation of the other co-applicants. So I'd ask that they all be placed under oath, please.
Ms. Matilde Treviño, Valeriano Hernández Jr., Silvia Ramos, San Juanita San Miguel, Ernestina Treviño. Let me ask you all, if possible, to raise your right hands. That each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God.
Yes. Yes.
The court has heard yes from every person. You may lower your hands. Mr. Maddox, one witness at a time. Go ahead.
Yes, Your Honor. I'm gonna start with Mrs. Trevino. I just ask the court to take judicial notice of the purported will of decedent and original death certificate that are the originals that have been filed.
Notice so taken.
Thank you. You please state your name.
Matilde Treviño.
And did your mother, Ramona Ernnandez, pass away on December 11th, 2024 here in Laredo, Webb County, Texas at the age of 96?
Yes.
And do you recognize the document that was filed with your application to be the last will of Ramona Ernnandez dated September 26, 2013?
Yes.
And was she at least 18 years of age and of sound mind when she executed that document?
Yes.
As far as you know, did she ever revoke that will?
No.
And 4 years have not passed since her death in the filing of this application, correct?
Correct.
And at the time of her death, was your mother a domiciliary and resident of Webb County, Texas?
Yes.
And did she have any children born or adopted after execution of that will?
No.
And did she have any marriage dissolved after the execution of that will?
No.
Does that will name any state, governmental agency, or charitable organization as a devotee?
No.
And now she did receive Medicaid benefits after March 1st, 2025, correct?
Correct.
But in fact, her receipt of benefits began in 2002 prior to the implementation of the Medicare State Recovery Program.
Correct.
And in fact, the MERP program acknowledged that your mother's estate is not subject to recovery and withdrew any claim in a correspondence to you.
Correct.
And that is shown in Exhibit B attached to your application.
Correct.
And Your Honor, I would ask that you take judicial notice of Exhibit B received from the Texas Medicaid State Recovery Program.
So take.
Thank you, Your Honor. Does your mother's estate owe any unpaid debt of any type?
No.
And have all expenses of her final illness and arrangements been paid?
Yes.
And other than the one piece of real estate, have all personal items, cash and accounts been distributed?
Yes.
And so the only item that we need title to pass is her residence?
Correct.
Okay, thank you. That's all I have, Your Honor. I'll call next San Juanita San Miguel.
Yes, sir.
Give me 1 second.
Hi, could you please state your name for the record?
San Juanita, San Miguel.
And Ms. Ramona Ernnandez was your mother?
Yes, sir.
And you heard your sister Matilda testify about the details of this application?
Yes, sir.
And is everything that she testified to true and accurate to the best of your knowledge?
Yes, sir.
And in fact, you signed before a notary at my office a proof of death and other facts stating all the same facts under oath.
Yes, sir.
Your Honor, that's all I have, if that's acceptable.
Yes, sir.
Thank you. I would call Valeriano Ernnandez Jr. Mr. Hernandez, could you please state your name for the court?
Valeriano Hernández Jr.
And Ramona Ernnandez was your mother, correct?
Yes.
And you heard your sister Matilda testify about the details of this application and your mother's will?
That's correct.
And everything that she stated is accurate and true and correct?
Yes.
And you signed before a notary at my office a proof of death and other facts stating all those specifics that was filed with the court?
That's correct.
That's all I have.
All right.
Mr. Hernandez. Silvia Ramos. I bet you can guess.
Yes, my name.
Can you please state your name?
Sylvia Ramos.
And Ramona Ernnandez was your mother?
Yes, that's correct.
And your sister Matilde testified as to the details of her passing her will in this application?
Yes, that's correct.
And everything she testified was true and correct?
Yes, sir.
And you signed a affidavit, swearing to all that was at my office, that was
Yes.
filed?
Yeah, that's correct.
That's all I have.
All right.
And, the other co-applicant is Tina Trevino.
Hi.
Could you state your name for the record?
Ernestina Trevino.
And Ramona Ernnandez was your mother?
Yes, sir.
And you heard your sister, Matilde Trevino, testify as to the details of her passing, her will, and this application?
Yes, sir.
And all that she stated was true and correct?
Yes.
And you signed a proof of death and affidavit stating all those facts specifically also that was filed in the case?
Yes.
That's all I have from the witnesses, Your Honor. I believe the evidence shows that there was no need of an administration. The return has been on file for the requisite time. And so I'd ask that the will be admitted as a muniment of title. And I'd also ask that the court waive the requirement of their state's code 257.103 regarding the affidavit of distribution, because all of the beneficiaries are co-applicants. All of the estate has been distributed except one piece of real estate that will pass as a muniment by the muniment of title. So I have submitted a proposed order in that form.
Ms. Trevino, Mr. Hernandez, Ms. Ramos, Ms. San Miguel, and Ms. Trevino, in your mother's case, cause number 2025 PB 962L2, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider admitting your mother's will into probate as muniment of title. The court hereby takes judicial notice of the entire case file, which includes your mother's original death certificate, her original will, the citation by posting, and the proof of death that each of you have executed. The court has now also had the benefit of hearing from each of you under oath in open court. The court at this time finds that your mother unfortunately passed away on the 11th day of December 2024 in Laredo, Texas, County of Webb, at the age of 96. The court finds that she, in fact, left a valid and executed unrevoked will dated September 26, 2013. The court finds that after the will was signed, she did not have any kids, neither did she adopt any children. The court finds that neither was any marriage dissolved for her. The court finds that pursuant to that will, she did not name the state of Texas or any state or charitable organization as devisees. The court finds that there is no need to administer your mother's estate. The court finds that you have met all of the requirements, including the requirements under section 257.103 of the Texas Estates Code, because the material portions of the will have in fact been fulfilled. And there's certain terms that have not yet been fulfilled. The court finds that you are entitled to the request that you are seeking. The court hereby admits your mother's will into probate as muniment of title. The court has reviewed the order filed by your lawyer. It is in due form. I have signed it, and I am tendering the original to the clerk's office. Does anyone have any questions for the court? I wish you all the best, and you have the court's sincere condolences. Have a good day. Any other cases for Mr. Maddox?
No, Your Honor.
It's good to see you, counsel.
Thank you, Your Honor.
Yes, sir. Have a great day.
Next person, Counsel Gabriela Garcia, page 4, number 8.
This is the estate of Mr. Addy, cause number 2025 PB 588L2. Court marks Ms. Gabriela Garcia present in person. Karen Kelly, are you present?
Yes, Your Honor. My name's actually Kish now. That's my maiden name.
Apologize for the oversight. Karen Kish?
Yes, Your Honor.
Welcome to court, Ms. Kish. The court marks you present. You're participating by video conference. Rodolfo Santos, are you present?
Good afternoon, Your Honor. Rudy Santos on behalf of intervener Melanie Urbina.
Welcome to court, Mr. Santos. Court marks you present by video conference. Are there any parties present?
Yes, Your Honor.
Tell me your name, please.
Sai Chandra Mumadi.
Mr. Mumbadi, welcome to court. The court marks you present. You're participating by video conference.
And Your Honor, Jacob Flores representing Sai Mumadi.
Representing who, I'm sorry?
Sai Mumadi.
Understood. Welcome to court, Mr. Flores. The court marks you present by video conference. Are there any other persons, witnesses, parties, lawyers, or anyone else present on this case?
Yes, Your Honor. Elizabeth Vela present. I was appointed court appointee for the safe deposit boxes.
All right, so noted. Welcome to court, Ms. Vela. Any other persons present? Ms. Urbina, are you present on this case?
Oh, yes, I'm present.
And tell the court what your relationship is to this case.
I'm trying to prove that my father is my father.
Your
I'm
Honor,
the daughter of Praduma Mumadi.
Your Honor, she's in error, and we have filed a motion for genetic testing pursuant to 204.051A of the Texas States.
I see that. This is your client. Understood. Welcome to court, Ms. Urbina. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is present and also participating by video conference. Are there any other parties, lawyers, witnesses, any other persons present on this case? All right. Counsel, what is the announcement?
Your Honor, I would like to withdraw our motion to withdraw as counsel. When we filed that motion, the case was on an uncontested track, and the amended application by counsel, Ms. Kish, identified our understanding of my client's interest accurately. But now that an intervention has been pled, Sai has asked us to stay on through the determination of heirship.
All right, so you're withdrawing the request to withdraw. Understood. Any objections to any of this by any person? All right, the withdrawal will not be heard. What other announcements are there?
Your Honor, we don't have any objection to Ms. Urbina attempting to prove her heirship. There's, nothing we can. We can put on testimony that no one knows who she is, but she has a right to prove it.
All right, so I guess let me take this step by step then. So the purpose of our hearing today is twofold. One is an agreed motion to withdraw as counsel that has been now withdrawn. The second is a plea and intervention for application to declare heirship. This is your filing, Mr. Santos. What would you like the court to know?
Your Honor, we filed the plea and intervention about a week ago. There's been no objections to it. Since then, we filed a motion for genetic testing. This is an individual that's pretty much raised my client. And I believe it's been my understanding that it might not even be contested. In the event that this is going to be contested with respect to our heirship, then we would be asking for mandatory genetic testing.
Well, sort of. So, there's two requests there. First is the plea and intervention. The court has heard that there is no objection, and I think the court even heard that there could be an objection. But just in case, right? Let's put it on the record. Any objections to the plea and intervention from any person?
Your Honor, I would like to just ask that I was not served, and the court wasn't even able to serve me notice of this hearing. I learned of it from Sanchander Mumadi's mother. I need to be able to address that and fix whatever reasons I cannot get notice. I also haven't had notice of the, I have the interpleading, but I don't have any notice of a DNA test request.
That's the second point. So let me focus on the first.
Your Honor, the plea and intervention is lacking in several areas. It doesn't list Ms. Urbina's date of birth or the other parent. And so my client has no knowledge of Ms. Urbina and is not aware of any parent-child relationship that was formed between his father and Ms. Urbina.
Your Honor, I don't believe there's any special exceptions on file.
I'm gonna pause everyone for a second. I'm gonna take one thing at a time. Mr. Flores, I'll rehear whatever argument you have on the plea, and then give Mr. Santos a chance to reply to that. But let me take up Ms. Kish's first point. Ms. Kish, it looks like you are right. Tell the court what your email address is.
Karen at Kish, Kisch lawfirm.com. And it seems that that's in there, but it's not getting to me.
Well, so what the official record says, so the e-service went to the Webb County Court at Law to email address, Jenna Innings, Sai Momdi, Gabriela Garcia, Megan Edwards, Jacob Flores, Rudy Santos, Karen Kish, and Cynthia Santos. And for the email address provided to you, it is one of two that shows an error message. Which is odd. And there's no other information provided by the email, excuse me, the e-service provider other than there was an error. There was also an error with someone from Mr. Santos's law office. I guess I don't know if that's going to be a reoccurring thing, although I can tell you that the next few filings in the case also show an error for you.
I do have a call into the service to see if there's some reason. I don't know if you know this. If I filed an appearance in the case, would that override it?
I don't know that that's the answer. So there's either one of two things, and none of this, by the way, is legal. I'm just brainstorming technological roundabout workarounds, I guess. So just for purposes of the record, the email address provided or being used to send information to you and your client is KAREN at KISCHLAWFIRM.com. What I would suggest going forward is several things. Number one, check the spam to see if it's not in there, but I would suspect that it isn't because there's an error message. What I would next suggest is to go in and add at least 2 more email addresses, another person in your law firm, another lawyer, a paralegal, a legal assistant, legal aid, or something, so that there's at least 2 others, and file something just to test it out, a proposed order, a fiat, something that isn't, I mean, an advisory, just to see if those 2 new addresses get, because for Mr. Santos, his assistant, I guess, didn't get the first but got the next. So I don't know.
Okay.
All right. So the court shows that there is no actual notice to Ms. Kish. Having said that, Ms. Kish, do you object to the court hearing the plea in intervention?
Hearing the plea? No, Your Honor, we don't object.
All right. So despite there being no proven notice, there's attempted service, but there is no objection to the only person that did not receive it. That being the case, let me now hear, this is your plea in intervention, Mr. Santos.
Your Honor, this is an interested error who's filed a intervention in the lawsuit. It's been timely. It hasn't been tested. There are no objections to it. She has standing. This is an individual that is a biological child of the decedent, and she's trying to establish her heirship in this proceeding. Our understanding is that these brothers were actually aware of my client's existence, but for whatever reason, she was omitted from service in connection with this suit.
Response from any person?
Your Honor, my client has told me that he doesn't have any knowledge of Ms. Urbina.
And Mr. Flores, I believe you wanted to say something on the record on this.
Yes, Your Honor. My client as well has advised me that he has no knowledge of having a sister.
Well, nothing I can do with any of this, Mr. Flores and Ms. Kish. What what are your respective clients' legal positions as to the plea and intervention?
My client has agreed to, if she can prove it via DNA testing, then so be it. But that there's no birth certificate with his father's name on it. There's no other evidence of living as a parent or a child. It's just that she's going to have to prove it from a DNA test.
Mr. Flores? Oh, and go ahead, Mr. Flores.
That we have the same position. There's no date of birth pled in their pleadings. There's no name of the other parent for us to do any research as to whether or not there was a parent-child relationship. We're not opposed to DNA testing. I believe his motion was asking that each party bear the cost of their DNA testing. I would object to the cost being assigned out to my client, and cost sharing could be done after parentage has been determined.
So if I understand everyone correct, Mr. Santos has filed this plea and intervention. Nobody objects to the actual plea, but they would object to it not being proven and would give the intervener the burden of proving that they in fact are. All right, that is clear on the record. So let's move on then to the request for genetic testing, because that was filed today at 5:33 in the morning. We're not set for that. So let me ask, since Mr. Santos has filed this today, I wasn't even aware of it until the clerk showed it to the court during this hearing. First question, I guess it's going to be a two-part question, first to Ms. Kish and then to Mr. Flores. Number one, do you or your client object to the court hearing it? And two, is there an agreement with regard to testing? Ms. Kish?
Once again, Your Honor, I haven't seen it. I still don't even see it on the docket, but I'm of the same mind as Mr. Flores. I believe if there's going to be testing, the cost of that needs to be borne by the person that's intervening.
Same questions, Mr. Flores?
Yes, Your Honor. We don't object to the testing, and we don't object to hearing it today, as we'd like this to move forward as quickly as possible, but we do think that the cost needs to be borne by the intervener. If it is determined that she is a child of the decedent, then the cost sharing could be dealt with later by the administrator.
Your Honor, that's not something that we disagree with.
This is something that, I'm sorry, say that again?
That is not something that we disagree with. We're in agreement.
Well, it sounds then by agreement, the court will approve the request for genetic testing and will order that Ms. Urbina be responsible for all of those costs. These are the orders of the court that are due to the court on or before
July 27th by submission.
All right, so it's not a hearing date, just it's an orders due deadline. Obviously, if you file it before, the court will sign off on it before. And there is also a motion to set deadline on August 31st at noon. All right, anything else pending on this case, Ms. Kish?
Not that I'm aware of, Your Honor, no.
Mr. Flores?
No, Your Honor.
Mr. Santos?
I'll believe so, Judge.
Well, I do need to set a hearing on the actual declaration of heirship, and that can't happen until after the tests are performed. I tell you what, without knowing anything else, Ms. Rodriguez, give us a final hearing date in September.
September 15th at 2 p.m.
Oh, you can probably have an earlier setting if all the results are in and you're ready to go forward. You can request an earlier setting. I just want to set this so far out that you have sufficient time to file this order before July 27th when it's due. File anything you want, amend your pleadings if that requires it or not, and have you all talk and communicate before then. If there is no agreement and there is no other action that is pending, we will come back for final hearing on September the 15th. Between now and then, if there are any changes in circumstances depending on this test, file your request in writing with the court, and the court will set those for hearing as soon as possible. Anything else on this case, Ms. Kish?
No, Your Honor, thank you.
Mr. Santos?
No, Your Honor.
Mr. Flores?
No, Your Honor, thank you.
Ms. Vela, what I think for the purposes of your appointment, I believe your services have been fully executed, have they not?
Yes, I had a question. I have an application for my fees prepared for filing. My only concern before that was which party would be responsible for the fees since I wasn't at the hearing. And I don't believe that the order addresses that. I'm not sure if it's a particular party or the estate in general.
Ms. Vela, and your application, tell the court what your application says and shows. What do you believe are your reasonable and necessary attorney's fees?
So I spent at least 4.6 hours interviewing, going in person to the bank and following up with the bank representatives to confirm whether Mr. Mamadi had any safe deposit boxes at the Bank of America and Wells Fargo locations. After several weeks of following up with them, they were able to confirm that Mr. Mamadi did not have any safe deposit boxes at either location. And I'm requesting a reasonable fee of $900 for my services.
Does any person here have any questions for Ms. Vela or any objection to the court finding that $900 for her services in this case are reasonable and necessary for this community?
No, Your Honor.
All right, having heard that there are no objections, the court adopts that finding, finds that Ms. Vela has performed at least 4.6 hours of work. The court finds that $900 are reasonable and necessary in this case. The question for the court then becomes whom to assign the fees to. Let me ask you both this, Ms. Kish and Mr. Flores. It seems to me that there is going to be no, I mean, there may be a legal dispute, but I guess in the real world right now, there isn't a dispute as to the two heirs of decedent. And it sounds to the court, unless you all have an agreement or an alternative, that the court should divide those fees equally between your two clients and ostensibly reimbursable by the estate when the heirship is finally declared. Any objection to that, Ms. Kish?
None, Your Honor, we agree.
Mr. Flores?
No, Your Honor.
All right, then each of your clients will pay 1/2 of that $900 fees to Ms. Vela within 14 days. Ms. Vela, prepare that order, send it to the court before July 27th at noon by submission, knowing that the estate will ultimately likely reimburse each of those two persons. Ms. Garcia, anything to add on this case?
Further, Your Honor.
All right. Does any person have any questions? All right. All right. I look forward to calling this case on September the 15th at 2 p.m. I wish all persons well. Have a good day.
Thank you, Your Honor.
Next in person, Counsel David Garcia, page 7, number 16.
I'm sorry.
Page 7, number 16.
In the matter of Andres Ivan Castillo, cause number 2026, PB 61702, court marks Mr. Garcia, present in person. Good afternoon.
Good afternoon, Judge.
Court marks Mr. Russell Jordan, present by video conference. Good afternoon, Mr. Jordan.
Good afternoon, sir. I believe my client's present in person, Mr. Jose Castillo, and he'll need the assistance of an interpreter, Your Honor.
We'll begin Spanish language interpretation now. Are you Jose Ivan Castillo?
¿Es usted José Iván Castillo?
Sí.
Yes.
Welcome to court, Mr. Castillo. The court marks you present in person.
Bienvenido al tribunal, señor Castillo. El tribunal le marca en persona.
As you can see from that screen, your lawyer is present and participating by video conference.
Como usted puede ver por medio de la pantalla, su abogado se encuentra presente por medio de videoconferencia.
What is the announcement, Mr. Jordan?
We have for the court an application for guardianship, Your Honor, and Mr. David Garcia was appointed ad litem on that matter, sir. And to that end, I'd ask the court to take judicial notice of the court's entire file and our filings in particular. especially the certificate of medical examination, the certifications that were issued by the Office of Court Affairs, and the fact that citation was achieved in compliance with law, Your Honor.
Notice so taken. Is Mr. Castillo your only witness?
Yes, sir.
Mr. Castillo, would you raise your right hand?
Señor Castillo, levante su mano derecha.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
¿Jura o afirma que el testimonio que dará ante el día de hoy será la verdad bajo el amparo de Dios? Yes.
You may lower your hand. Mr. Jordan, go ahead.
Thank you, Your Honor. Mr. Castillo, could you please state your full name for the record?
Señor Castillo, por favor, diga su nombre completo para el récord.
José Iván Castillo Castillo.
José Iván Castillo Castillo.
And where do you currently reside, sir?
¿Dónde vive usted actualmente, señor?
En Laredo, Texas.
En Laredo, Texas.
And how long have you resided in Laredo, Webb County, Texas?
¿Cuánto tiempo ha estado viviendo usted aquí en Laredo, Texas?
22 años.
22 years.
Okay. And what is your relationship to Andrés Iván Castillo?
¿Y cuál es su relación con Andrés Iván Castillo?
Es mi hijo.
He is my son.
And you feel it's absolutely necessary for the court to grant you a guardianship over your son?
Y usted está pidiendo del tribunal y le está diciendo al tribunal que es necesario que se le otorgue ser guardián sobre su hijo.
Correcto.
Correct.
And we've discussed the fact that essentially there are no other legal remedies that will give you the type of authority that you need to help your son run his life.
Y hemos hablado sobre el hecho de que no hay algún tipo o otro remedio legal para que usted pueda ejercer autoridad sobre su hijo.
Correcto.
Correct.
Is your son able to care for himself, Mr. Castillo?
¿Su hijo puede cuidarse por sí mismo, señor Castillo?
No.
No.
And what is his diagnosis specifically?
¿Y cuál es el diagnóstico de él de manera específica?
Autismo severo, DSP, y convulsiones.
Severe autism, convulsions, PhD.
And when was he diagnosed with autism and epilepsy?
¿Cuándo fue que él diagnosticado con autismo severo y con epilepsia?
A epilepsia se le diagnosticaron hace 2 años y medio y el autismo al año y medio. Al año y medio de su edad.
He was diagnosed with epilepsy 2.5 years ago, and he was diagnosed with autism when he was 1.5 years old.
Is your son able to speak, sir?
¿Su hijo puede hablar, señor?
No.
No.
Is he able to feed himself, bathe himself, things of that nature?
Él puede alimentarse por sí mismo, bañarse por sí mismo, cosas así.
No.
No.
Does your son own any property, sir?
¿Su hijo es dueño de alguna propiedad?
No.
No.
Does he receive government benefits?
¿Recibe beneficios del gobierno?
Sí.
Yes.
What type of benefit, if you could be more specific?
¿Qué tipo de beneficios? Si puede ser más específico.
Ahorita el Medicaid nomás.
Medicaid only.
And is he able to manage his property, sir?
¿Y él puede manejar sus bienes reales, sus propiedades?
No.
No.
Okay. And you're not disqualified for any reason from acting as his guardian, correct?
Y usted no está descalificado de alguna manera o razón para actuar como su guardián, ¿correcto?
No.
No.
No. You understand that you're going to have to make reports regarding your son's well-being and any reports regarding income and expenses made on his behalf, correct?
Usted comprende que tendrá que hacer reportes anuales referente al bienestar de él y cualquier tipo de dinero o cualquier tipo de gasto que se refiere a él, ¿comprende?
Sí.
Yes.
And you're perfectly capable of complying with those requirements, correct?
Y usted está capaz de cumplir con esos requisitos, ¿correcto?
Totalmente sí.
Totally, yes.
Now, standing next to you is the attorney David Garcia that's been appointed to represent the interest of your son, Andres. Have you had sufficient time to talk with Mr. Garcia about your son's conditions or any special conditions that may exist in the relationship between you and your son?
Ahora, a un lado de usted está el abogado David García, el cual ha sido interpuesto como abogado ad litem para representar los intereses de su hijo. ¿Usted ha tenido tiempo suficiente para hablar con el abogado García referente a la condición de su hijo y su relación con su hijo?
Sí.
Yes.
And you believe that Mr. Garcia correctly understands your son's position?
¿Y usted cree que el abogado García comprende de manera correcta la posición y lo que su hijo necesita?
Sí.
Yes.
Now, you understand if the court should grant you the guardianship, you will have what's called a fiduciary relationship between you and your son, meaning that as his guardian, you will have to put your son's interest before your own.
Ahora, usted comprende que si usted es el guardián de su hijo, usted tendrá una relación fiscal y en la cual usted tendrá que interponer las necesidades de su hijo antes de las de usted, ¿lo comprende?
De acuerdo, sí.
In agreement, yes.
Do you have any problem doing just that?
¿Tiene algún problema de hacer eso?
No.
No.
Your Honor, I believe that's all I have by way of a testimony from this witness. Mr. Garcia has been gracious enough to file a report, but he's also been gracious enough to appear in person, Your Honor. I don't know if the court has any questions of him or would have me question Mr. Garcia regarding any of the facts presented so far.
I would just like to clarify.
Let me hear the translation.
I'm sorry. Can I go ahead?
A su señoría, el abogado García interpuso el reporte, sin embargo, ha estado en persona durante este tiempo. No sé si usted necesite que él haga preguntas para el testimonio del abogado.
Mr. Garcia, do you have any questions for Mr. Castillo?
I just want to clarify one thing. Mr. Castillo, does your son receive Social Security?
Quiero clarificar una cosa, señor Castillo, ¿su hijo recibe beneficios de seguro social?
Bueno, él fueron cancelados ahora que cumplió los 18 años. Acabo de hacer la aplicación para disabilidad.
They were canceled when he turned 18 years old, and I have now made the application for his disability.
Mr. Castillo, you reside at 8604 Superior Drive?
Y señor, ¿usted vive en 8604 Superior Drive?
Correcto.
Correct.
And your son also resides there with you?
¿Y su hijo también vive ahí con usted?
Sí.
Yes.
And does anybody else live there with you?
¿Vive alguien más con usted ahí?
No.
No.
Okay. And your work hours are such that you get out of work when your son gets out of school. Is that correct?
Y su horario de trabajo es que usted cuida o trabaja mientras que su hijo está en la escuela, ¿correcto?
Correcto.
Correct.
And so you're with your son all the time. In other words, he's never alone.
Lo que quiere decir que usted está con su hijo todo el tiempo y él nunca está solo.
Correcto.
Correct.
Judge, I have no more questions for the witness, but I do have some comments at the end of when you're ready.
Su señoría, no tengo más preguntas para el testigo, sin embargo, tengo comentarios cuando usted esté listo.
Mr. Garcia.
Yeah, so I reviewed the medical records and I have also met with the proposed guardian and the proposed ward. And he is incapacitated and his condition is challenging, although to his credit.
Let me hear the translation.
Su señoría ha revisado los récords médicos y también he hablado con el guardián propuesto y con el pupilo propuesto. Él sí tiene algún tipo de necesidad, sin embargo.
He's able to manage the ward very well. And I don't know.
Did you say ward?
The ward.
The ward. Y el señor puede manejar al pupilo de buena manera.
I visited the home. It's very tidy. It's kept safe. There are no items around. There's no clutter. The backyard was also, you could tell that they keep it nice and clean where there's nothing, you know, it's nice and clean. He also has a camera system outside just to make sure, I guess, he doesn't lose track of it.
Visité el hogar, es un hogar seguro, no tiene, no es, está libre de muchas cosas. También pude observar que está limpio, además de que el señor tiene un sistema de cámaras y que su patio trasero está bien cuidado.
And I don't see any alternative or a better alternative than for the proposed guardian to be named guardian for the ward.
Y no veo alguna otra alternativa o mejor alternativa más que el señor sea interpuesto como guardián del pupilo.
And they're constantly together.
Y están constantemente juntos.
I guess the only question I have, Mr. Jordan, is the necessity for guardianship over Andres's estate.
Mi única pregunta, abogado Jordan, es la necesidad de que el señor sea guardián de los bienes del pupilo.
Well, Your Honor, I didn't see it as redundant. As I had my client put on the record, he does receive benefits. Those benefits will need to be managed, sir, in meeting with the ward, and I'm sure Mr. Garcia will agree. I'm not sure he's even aware that he receives any money from the government or how he would spend it, Your Honor. So in an abundance of caution, I've requested a guardianship of the person and the guardianship of the estate, unless the court deems that to be unreasonable or unnecessary, sir.
Su señoría, el pupilo recibirá o recibe beneficios y no creo que él tenga o sea, ha demostrado que no tiene la capacidad de manejarlos, además de que no creo que él esté al tanto de que reciba beneficios del gobierno y de que los pueda manejar de alguna manera. Y en la abundancia de precaución, por eso fue que interpusimos las aplicaciones para ser guardián de la persona y de los bienes, al menos que el tribunal vea de alguna otra manera.
Well, I think if you're asking the court, I think the court has heard evidence and testimony that because that there is no estate for Andres, granting a guardianship of the estate would not be unreasonable. It would, however, be unnecessary.
I see.
Debido a que se ha demostrado por evidencia a través del testimonio que no hay bienes, será innecesario que se interponga o que se otorgue guardián de los bienes.
Because if there are only federal funds that are being managed on behalf of a ward by a parent, loved one, or guardian, then the federal government has sufficient safeguards in place to protect those.
Debido a que si es que son bienes federales los que recibe el pupilo, el gobierno federal tiene suficientes recursos para asegurarse que esos sean utilizados de buena manera.
And if the court granted guardianship of the estate, then it would place an additional burden on Mr. Castillo to file, in addition to annual reports, also annual accounts.
Y si este tribunal otorga guardián sobre bienes, será una carga adicional, no solamente de reportes sobre la persona, sino reportes sobre los bienes.
Thoughts or comments, Mr. Jordan?
I certainly understand the court's position and appreciate the court's help. It is very obvious to me that my client has enough responsibility in his life. And having understood that, sir, I would respectfully modify my request to include guardianship of the person only, sir.
Comprendo lo que el tribunal ha dicho y le agradecemos al tribunal debido a que mi cliente ya tiene suficiente responsabilidad y modificamos nuestra petición para que sea solamente guardián de la persona.
Thoughts, comments, or objections, Mr. Garcia?
No comments, no objections, sir.
No hay comentarios ni objeción por parte del abogado García.
Mr. Castillo, in the case of your son, the court finds that it has jurisdiction.
Señor Castillo, en el caso de su hijo, el tribunal halla que tiene jurisdicción sobre este asunto
The court takes judicial notice of your son's entire case file,
y toma notificación judicial del archivo entero de su hijo,
which includes your criminal background check,
su historia criminal,
the medical examination,
la examinación médica,
all the certificates, and the notices.
todos los certificados y notificaciones.
The court finds that your son is wholly and totally incapacitated.
El tribunal halla que su hijo está incapacitado de manera total.
He cannot care for himself, but relies on you.
Puede cuidarse a sí mismo y le necesita a usted.
The court finds that it is in his best interest to appoint you as guardian over his person.
El tribunal halla que está en el mejor interés que se le interponga a usted como guardián de su persona.
The court grants that request and appoints you as guardian over your son.
Y el tribunal le otorga a usted su petición y se le interpone a usted como guardián de su hijo.
And the court further finds that your son is very lucky to have you in his life.
Que su hijo es afortunado de tenerle a usted en su vida.
Let me have these orders of guardian over the person be due honor before.
July 29th by submission.
Mr. Garcia, anything to put on the record with regard to fees?
Like, I think $500 would be fair, Judge, although for quite a bit of time. But I just think in this particular case, I wouldn't want to go more than that.
Abogado García, algo referente a sus honorarios, su señoría, aunque hice un trabajo extenso, creo yo que $500 son suficientes en este caso. No quisiera poner algún tipo más de responsabilidad sobre el señor.
Comments or objections, Mr. Jordan?
No, none, Your Honor.
Court finds that reasonable and necessary fees in this case are at least $500, so ordered.
El tribunal ordena los $500 de honorarios debido a que son razonables.
Mr. Jordan? Yes, Your Honor. I wanted to mention to you the issue of bond, Your Honor. I'd ask the court to dispense of it if possible, or to set a bond that's very reasonable given the circumstances.
Su señoría, en cuanto a fianza, estaremos pidiéndole al tribunal que se ponga en cero o una fianza razonable debido a las circunstancias.
Bonds legally can't be waived, but what the court can do in this situation is set a $500 surety bond.
Perfect, Your Honor. Thank you.
En $500 bajo firma o seguridad.
Right, so the court is going to sign those orders as soon as they come in, on or before July the 29th.
El tribunal va a firmar esas órdenes en cuanto sean archivadas en o antes del 29 de julio.
Mr. Castillo, do you have any questions for the court?
Pregunta para el tribunal, señor Castillo.
No, gracias.
No, thank you.
Mr. Castillo, I wish both you and your son all the best.
Solo mejor a usted y a su hijo.
Have a good day.
Thank you,
I
Judge.
appreciate the court's help, Your Honor. I believe that's all I have before the court.
Good to see you both, counsel. Have a great day.
Likewise. Mr. Garcia, thank you so much. I owe you a steak, sir.
Next in person, counsel Fred Trevino, page 6, number 15.
This is the estate of Ector Javier Gaon, cause number 2026 PB 515L2. Good afternoon, Mr. Trevino.
Good afternoon, Your Honor.
Court marks you present in person. Are you Maria Isabel Gaona Woods?
Yes, Your Honor.
Welcome to court, Ms. Woods. The court marks you present. You're participating by video conference. Are you? Hold on a second. Are you Ana Teresa de Batur? I'm going to ask that you unmute your device.
Yes, sir.
Welcome to court, Ms. de Batur. The court marks you present. You're participating by video conference. Are you Adriana Torres?
Yes, sir.
Welcome to court, Ms. Torres. The court marks you present and participating as a witness by video conference. Are you Paul Torres?
Yes, Your Honor.
Welcome to court, Mr. Torres. The court marks you as a witness, also participating by video conference. Is there any other person present or participating on this case that the court has not already called? All right, Mr. Trevino, what is the announcement?
Your Honor, at this time, we're requesting that the court order that the administration of Mr. Hector Gaona's estate be administered by the co-applicants, Ms. de Botur and Ms. Woods, Isabella Woods, requesting that the court grant the request, the application to determine heirship and for the application of administration.
On the airship, was a lawyer appointed as ad litem?
Yes, Your Honor, and a report was submitted by Attorney Benavid.
Mr. Cantu, who was present, that's right. All right, who are your witnesses?
Mr. Paul Torres and Adriana Torres, Your Honor, and they've already submitted affidavits as well as a witness.
Oh, I do see that. So so they're here. Are you asking that they not testify?
But they're not, I wasn't sure, just an abundance of caution.
I
if
see.
Since they
Okay.
submitted the affidavit, Your Honor.
All right, well, it's your case. I mean, you don't need them, but they're here. So if you don't, I'm good with that.
Okay, Your Honor. Well, in that case, I guess we can excuse Mr. Torres and Mrs. Torres.
Just all right, in the estate of Ector Javier Gaon, cause number 2026 PB 515L2, the court finds that it has jurisdiction. The court takes judicial notice of the entire case file, including the original death certificate, all the citations, publications, postings, the waivers. The court hereby takes judicial notice of the affidavit of Adriana G. Torres and Paul Torres. Let me do one thing, Ms. Torres and Mr. Torres. Would you raise your right hands? Ms. Torres, unmute your device, please. That each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Both have said yes, you may lower your hands. Is your true and correct name Adriana Torres?
Correct, sir.
Ms. Torres, you filed an affidavit with the court. Is everything you said in there true and correct?
Yes, sir.
Anything you want to change?
No, sir.
Same question to you, Mr. Torres. Is your true and correct name Paul Torres?
Yes, Your Honor.
The court has taken judicial notice of the affidavit that you filed. Is everything that you put in that affidavit true and correct?
Yes, Your Honor.
Anything you want to change?
No, Your Honor.
All right, that's sufficient for the court. Ms. Woods and Mr. Vator, in this case, cause number 2026 PB 515L2, the court finds that it has jurisdiction. The court has already taken judicial notice of the entire case file. The court has now had the benefit of hearing both from Mr. Torres and Ms. Torres under oath, having also taken judicial notice of their affidavits. The court has also received, reviewed, and considered the ad litem report in this case. The court finds that the heirs of Ector Javier Gaona are Maria Isabel Gaona Woods and Ana Teresa de Vator. Heirship is so declared, and the court is signing a judgment declaring heirship to that effect. All right, as to Mr. Torres, Ms. Torres, that concludes your portion here. You're welcome to stay on. If not, you're excused. Have a great day.
Thank you, Your Honor.
Mr. Trevino, as to the application, who are your witnesses, if any?
Your Honor, it would be Miss Ana Teresa de Vator and Maria Isabel Gaona Woods.
Ms. Gaona Woods and Mr. Vator, would you both and each raise your right hands? Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor. Yes, Your
Both
Honor.
have- Thank you both. Both have answered yes. You may lower your hands. Mr. Trevino, one witness at a time. Go ahead.
Yes, Your Honor. Miss Woods, could you please state your name for the record?
Maria Isabel Gaona Woods.
And please state the address where you reside.
Yes, it's 2021 Placitas Drive, Laredo, Texas.
And how are you related to the deceased?
I am his daughter.
Okay. And please state the name of the deceased.
Ector Javier Gaona.
And he passed away on October 14th, 2023.
That is correct.
And to the best of your knowledge, he did not leave a will and died in
He
testament.
did not. No, he did not.
And 4 years has not passed since his passing.
No, it has not.
And he was a resident of Webb County at the time of his passing.
Yes.
And you are not disqualified by law from serving as an administrator or being entitled to laws by law to the letters of administration.
That is correct. I'm not disqualified.
Okay. And this court has jurisdiction and venue over this estate?
Yes.
And the decedent owned property described generally as real estate, cash, personal effects, and household goods of a probable value in excess of $75,000.
Yes.
And you believe that it's necessary to administer this estate. There's a
Yes.
necessity to administer the estate.
Yes,
Okay.
sir.
I believe that's everything I need for this particular witness, unless there's other questions that the court would need.
You may proceed with your next witness.
Ms. Devotor, could you state your name for the record?
Yes, my name is Ana Teresa Devotor.
Okay. And please state your address where you reside.
I reside at 30 Lakeshore Drive, Cold Spring, Texas.
Okay. And how are you related to the decedent?
The decedent was my father.
Okay. And he passed away on October 14th, 2023.
Yes, sir.
And to your knowledge, he did not leave a will and died intestate?
You are correct. He did not leave a will.
Okay. And 4 years has not passed since he passed away?
Yes,
Okay. And he was a resident of Webb County at the time of his passing?
he was.
Okay. And there's a necessity for the administration of the estate to recover funds and distribute this estate?
There is.
Okay. And this court has jurisdiction and venue over this estate?
Yes, sir.
And you're not disqualified by law from serving as an administrator or, you're just not disqualified by law from serving as an administrator?
No, sir, I'm not.
Okay. And your father owned property described generally as real estate, cash, personal effects, and household goods of a probable value in excess of $75,000?
Yes, he did, sir.
Okay. And your father was never divorced?
No, sir, he was not.
Okay, and at the time of his passing, he was not married at the time?
No, he was a widower.
That's it, Your Honor. I rest on it.
Ms. Gaona Woods and Ms. Devator, in your father's case, cause number 2026 PB 515L2, the court at this time finds that it has jurisdiction over this matter. The court finds that your father passed away on October the 14th, 2023, having passed away intestate, that is without a will. The court finds that there is a necessity to administer your father's estate. The court finds that you are each and both qualified and you're not disqualified from serving. For all of these reasons, and having heard your testimony, the court finds that you should and are hereby appointed as co-independent executors over your father's estate. The court has signed an order to that effect, is tendering the original order to the clerk's office, and the court will cause letters of testamentary to be issued out to each of you. Ms. Gaona Woods, do you have any questions for the court?
No, sir.
Ms. Devator, do you have any questions?
No, sir.
I wish you both very well, and you have the court's sincere condolences.
Thank you.
Thank you so much.
The inventory, Mr. Trevino, on this case is due on September 17th at 9 a.m.
Your
Thank
Honor,
you.
you have not mentioned the bond.
Your Honor, and we're requesting the bond be waived because they're both the distributees and their administrators.
Right, the court, I think that's right. For this reason, the only heirs are the only independent executors. So they're each responsible to each and both. All right. All right, I've signed those orders and the inventory is due on September the 17th at 9 a.m. Thank you, Ms. Rodriguez. Any other cases for Mr. Trevino? All right, good to see you, counsel. Have a great rest of the day.
Thank you, Your Honor.
Court will stand at ease. Thank you. Have a great day. Court will stand at ease momentarily.
I unmuted it, but I haven't heard him.
Court is back in session and we are on the record. This is the civil probate and guardianship docket for Tuesday, June 30th, 2026. The time is now 4:30. Ms. Rodriguez.
Next in person, Council Cantu, page 6, number 14.
This is the estate of Philip Wesley Ogist, cause number 2025 PBA 15L2. Court marks Mr. Cantu present in person. Good afternoon, counsel.
Yes, Judge. Good afternoon, Judge.
Mr. Guillermo del Barrio, are you present?
Judge, he has filed his recommendation with the court, Judge.
Court will take notice of that. Nelson J. Holquist, are you present? Mr. Holquist, please step forward, step in front of the lower bench, pull a microphone as close to your mouth as possible, and tell the court, are you Nelson J. Holquist?
Yes, sir.
Welcome to court, sir. The court marks you present in person. The person to your right is your lawyer. Who is the person behind you, Mr. Holquist?
Judge, he'll be a witness, Judge.
All right, and what is this person's name?
¿Cuál es su nombre? Alejandra Martínez. Alejandra Martínez.
Announcement, Mr. Cantu?
Judge, and I believe we have one witness on Zoom.
Their name?
Carlos.
Carlos Guerrero, Your Honor.
Yes, Judge.
Mr. Guerrero, are you present?
Yes, sir.
Mr. Guerrero, welcome to court. The court marks you present. You're participating by video conference. Mr. Holquist, Ms. Martinez, Mr. Guerrero, let me ask you to raise your right hands.
Su mano derecha.
Mr. Guerrero, unmute your device. And just confirm for the court, Mr. Guerrero, that you are not driving.
I'm not driving.
All right. Mr. Guerrero, Ms. Martinez, and Mr. Holquist, do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, sir.
¿Jura o afirma que
Yes, sir.
ante el día de hoy será la verdad bajo el amparo de Dios? Yes.
All have answered yes. You may lower your hands one witness at a time. Mr. Cantu, go ahead.
Yes, Judge. So, I guess if I can start with the applicant, Judge, Mr. Holquist.
It's true.
Mr. Holquist, can you please state your full name for the court? Nelson Holquist. And sir, you're here on an application for letters of administration, is that correct? Yes, sir. And what was your relationship to Mr. Philip Wesley Holquist? He is my brother. And sir, he died here in Webb County, is that correct? Yes, sir. Sir, according to the application we have filed, your brother died January 6, 2021. Does that sound about right? Yes, sir. And when he passed away at the age of 72. Is that correct? Yes, sir. Sir, he left a home that you were seeking to administer and manage. Is that correct? Yes, sir. And at the time of his death, was he married? Yes, to Maria. What's her full name? Maria Castillo Ernnandez. Is her complete name Maria de Jesus Castillo Martinez? Yes, sir.
Yes.
Okay. And she married your brother on or about May 2015, is that correct? Yes, sir. And that also occurred here in Webb County, is that correct? Yes, sir. To the best of your knowledge, did they have any children? No, sir. And basically, so she would be the surviving spouse of your brother, is that correct? Yes, sir. Have you ever been convicted of a felony or anything that would disqualify you from serving as administrator of your brother's estate? No, sir. And is your testimony made before the court true and correct? Yes, sir. And you're asking the court to appoint you as administrator of your brother's estate? Yes. That's all the questions I have for Mr. Cavasos.
Next witness.
The next witness, I'll go ahead and ask a few questions to one of the witnesses. And ma'am, what is your full name?
Señora, ¿cuál es su nombre completo? Alejandra Martínez Guerrero. Alejandra Martínez Guerrero.
And you knew Mr. Philip Hawkins, is that correct?
¿Y usted conocía al señor Philip Hawkins, correcto? Sí. Yes.
He was married to Maria de Jesus Castillo Martinez, is that correct?
Y él estaba casado con María de Jesús Castillo Martínez, ¿correcto? Sí. Yes.
Did they have any children together?
¿Ellos tuvieron hijos? No. No.
Okay, and to your knowledge, she was the only heir he would have had, is that correct?
Y a su conocimiento, ella sería la única heredera de él. Sí. Yes.
Okay, and you live here in Laredo?
¿Y usted vive aquí en Laredo? Sí. Yes.
How long had you known Mr. Philip Hawkins?
¿Cuánto tiempo conocía usted al señor Hawkins? Lo conozco desde el año 2023. I have known them since the year of 2023.
About 3 years.
Alrededor de 3 años. No, contesté equivocadamente. No, I answered incorrectly.
Okay, how long have you known him?
¿Cuánto tiempo los ha conocido? Desde el 2003. Since 2003.
Okay, so for about 23 years.
Alrededor de 23 años. Correcto. Yes, correct.
Okay, and okay, and I'll go ahead and pass this witness.
Who is your next witness?
I'll go ahead and call Mr. Carlos Guerrero.
Mr. Guerrero, unmute your device, please. Go ahead, Mr. Cantu.
Yes, Mr. Guerrero, you are familiar with Mr. Philip Hawkins, is that correct?
Yes.
And you're also familiar with Maria de Jesus Castillo Martinez, is that correct?
Yes.
And when Mr. Philip Hawkins passed away, he was married to Mrs. Maria de Jesus Castillo, is that correct?
Yes, sir.
And he passed away, sir, January 6, 2021, is that about right?
Yes.
And when he passed away, did he have any, to your knowledge, did he have any children with Mrs. Maria de Jesus Castillo Martinez?
No.
Okay, so basically she's the only heir that that he would have, is that correct?
Yes.
Okay. Judge, I'll go and pass the witness.
Any other witnesses?
That's all we have for you, Judge.
All right, Mr. Hulquist, in your brother's case, cause number 2025 PBA 15L2, the court at this time finds that it has jurisdiction over this case, meaning this is the proper place, the proper court forum and venue to consider granting your requests. The court finds that your brother unfortunately passed away on the 6th day of January 2021. Intestate without a will. The court finds that at the time of his passing, he was married to Maria de Jesus Castillo Martinez. The court takes judicial notice of the entire case file, which includes your application, your brother's original death certificate, that citation by posting, the publication, both with the Laredo Morning Times and the Office of Court Administration, the consent of his wife, the affidavit of heirship of Rolando Castillo and Celia Flowers. And the court also takes judicial notice of the report by the attorney ad litem. The court finds that Maria de Jesus Castillo Martinez is your brother's only heir. Heirship is so declared. The court further finds that there's a necessity to administer his estate. The court finds that you are qualified and you're not disqualified from serving. So the court will appoint you as the administrator in your brother's case and will cause letters of testamentary to be issued out to you. The only question the court has, Mr. Cantu, has two questions. Mr. Del Barrio's fees been discussed?
Yes, I believe we took care of Mr. Del Barrio's fees, and if for some reason we haven't, we will take care of his fees.
And what is your request as to bond and why?
Judge, I don't know if the court wants to put maybe $500 surety bond, Judge. If the court, or whatever bond the court deems appropriate, Judge.
Without having the benefit of the inventory, how much is the estate worth in everybody's estimation?
So we have one home, I believe, Mr.
I think the home is valued at around between 175 and 200,000.
All right.
But that's the only item. Yes.
Court is gonna set a $10,000 surety bond. This is just a surety bond,
fine.
tendering the original signed orders to the clerk's office. Mr. Holquist, do you have any questions for the court?
No, thank
I wish, yes, sir.
I apologize. May I have Mr. Hogwarts execute the oath?
Yes, please do so. As he does that, Mr. Cantu, the inventory on Mr. Holquist's case is due on or before September 17th at 9 a.m.
Yes.
All right, that concludes this case, and you have the court's sincere condolences, sir, on the loss of your brother. Any other cases for Mr. Cantu?
Just the bond or due on July 29th by submission.
All right.
Yes, we'll submit everything
So
by
ordered.
next week.
All right. Thank you all. Have a
Thank you.
great day. Good to see you.
Maybe,
Yes, sir.
yes, always good seeing you, Judge. Thank you.
Online, Counsel Juan Jose Garcia, page 3, number 6.
The estate of Gloria Ferdin, cause number 2024 PB 43702. Good afternoon, Mr. Garcia.
Good afternoon, Your Honor.
Court martial present by video conference. Mr. Guillermo del Barrio, are you present? Court finds Mr. del Barrio not present. Jose Luis Ernnandez, are you present?
Present online.
Jose Luis Ernnandez, are you present?
I am present.
Welcome to court, Mr. Ernnandez. Court martial present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Mr. Garcia, what is the announcement?
In this case, Your Honor, I believe we're ready to proceed. It's letters of administration and for airship, Your Honor.
All right, and Mr. Ernnandez is your only witness?
Yes, Your Honor, the two witnesses submitted affidavits.
All right, Mr. Hernandez, would you raise your right hand? Do you,
Yes.
is your right hand raised?
Yes.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand. Mr. Garcia, go ahead.
Thank you, Your Honor. Is your name Jose Luis Hernandez?
Yes, it is.
And what is your relationship to Gloria and Ferdin?
I am her nephew.
Okay. And you currently live in 507 Las Palmas Avenue, Hidalgo, Texas?
Yes, I do.
And she died on or about July 23rd, 2023?
Yes.
Here in Laredo, Webb County, Texas, at the age of 83 years old?
Yes.
And the court has jurisdiction because her property, which is a house, it was located here in Webb County. Is that correct?
Yes.
Okay, and the property more or less is worth about $67,087.
I believe so. We never had it appraised.
Okay, but it's more or less around that?
More or less around that, yes.
Okay, and then she didn't have any children, correct?
Correct.
She was never married.
She was married once.
And her husband is deceased?
Yes.
And they didn't have any children between them, correct? Or they adopt any children either?
Correct on both counts. No adoptions.
Okay, so her heirs would be, she had her siblings, which is Alicia Ramirez, Josefina Galaviz, Guadalupe Garcia, and then Elida Hernandez, which was your mother.
Yes.
And from those, they all died, and the only heirs would be yourself, your sister Araceli Valdez, and Antonio Hernandez, your other brother.
Antonio Hernandez Jr., yes.
Okay, and as far as you know, your other three tias, Alicia, Josefina, and Guadalupe, did not have any children. Is that correct?
Yes, they had children.
But you don't know where there are?
No. Only we know only of two of them. We made contact with two of them, and it was a daughter of one and the son of the other. And
but you don't know their names?
Yes.
Okay, what other names?
One moment, let me check those real quick. They were listed on the documents that we submitted.
Okay, because on the application, we just have Alicia Ramirez, Josefina Galaviz, Guadalupe Garcia, and Elida Hernandez, your mother.
Yes, the first three sisters, they've been deceased for about 40 years or maybe more.
Okay, but
And
you're saying that you only know two of the children of which sister?
Hold on, we
Gonna be not the oldest sister, but the other two sisters. Hold on, I'm trying to.
Mr.
yeah, we're-
Hernandez, Mr. Hernandez, are you testifying from Hidalgo County?
Yes,
What building or residence are you in?
507 Las Palmas Avenue, Hidalgo.
Is that your residence?
Yes,
And who is in the room with you?
it's my wife. She's going through the papers. Lucinda Hernandez.
What is her name?
Lucinda Hernandez.
Spell my first name.
And is there any other persons with you in that room?
No.
I'm gonna ask that you not speak to your wife, you not have any communication, you're under oath and you're testifying. Do you understand this?
Yes.
All right. If you don't know an answer, it's okay to say, I don't know, because you are under oath. Do you understand this?
Yes.
All right. Mr. Garcia?
Thank you, Honor. And as far as you know, you don't know the addresses of those other children that they may have, correct?
Not the addresses, but but the son of the first lady is Ernesto Ramirez. That's from Alicia M. Ramirez. And from
But you don't know where he lives, correct? Or do you know?
No, we don't. I'm sorry. Yes, we do. Then, of course, Josefina Galaviz is Angie Charafa. Chari. I can't remember. Can't understand her name.
But Mr. Hernandez, do you know where your other cousins live, like their addresses? Do you know? Yes or no?
Yes. No, I don't have the addresses right now.
But you can get them?
Yes, we can get them.
Okay, and because I think on this one, I don't think there's been service on those other cousins that he's mentioning.
I think that's right. I was looking at the case file. Ms. Rodriguez, give us a setting in 60 to 90 days, please.
September 15th at 2 p.m.
All right, so I'm going to give you this time to talk to Mr. Garcia, Mr. Hernandez, give him all of that relevant information. It's necessary that all persons be served, especially all the heirs. And let me also ask you, Mr. Garcia, just ask Mr. Del Barrio to follow up and file an amended report.
I will, Your Honor.
All right, any other cases for Mr. Garcia?
No, Your Honor.
Good to see you, Mr. Garcia. Have a great day.
Same here, Judge. Thank you, you too.
Next online is Council Sarah Dunn, page
Thank you.
number 17.
This is in the estate of Dania Benavid Solis, cause number 2026, PB 735L2. Good afternoon, Council.
Good afternoon, Your Honor.
Welcome to court. The court marks you present by video conference.
Thank you.
Diana Lowry, Patricia Garcia. Any parties present?
They're both here, Your Honor.
Here online or here in your
Here online, yes.
I'm gonna ask that you unmute your device and tell the court, are you Diana Lowry?
I am.
Welcome to court, Ms. Lowry. The court marks you present by video conference. Are you Patricia Garcia?
I am.
Welcome to court, Ms. Garcia. The court marks you both by video conference, as you can see and hear from your device. Your lawyer is also present and participating by video conference. Counsel, what is the announcement?
We are ready to proceed, Your Honor. This is to offer the probate of the will of Diana Benavid Solis, and we are seeking appointment of her daughters as co-executors to administer the estate.
All right, and you'll be calling both to testify?
Yes, Your Honor.
Ms. Lori, Ms. Garcia, I'm going to ask that you raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, sir.
You may lower your hands. Ms. Dunn, go ahead. One witness at a time, please. Go ahead.
Yes. I would like to call Diana Lowry to the stand.
Yes.
Okay. Hi, Miss Lowry. Please state your name for the record.
Diana Lowry.
And what is your relationship to the decedent Diana Benavid Solis?
She was my mother.
When did Mrs. Solis die?
April 9th of this year, 2026.
And so 4 years have not passed since the day that she passed.
No.
And where did Mrs. Solis die?
In her house here in Laredo, Texas, Webb County.
Okay. And was she so she was residing here in Webb County on the day that she passed?
Yes, ma'am.
And so was the original document that was dated May 29th, 2015 that has been offered for probate in this cause, Mrs. Solis's will?
Yes.
And that has been delivered to the court, correct?
Yes.
To the best of your knowledge, did Mrs. Solis ever revoke this will?
She did not.
Did Mrs. Solis ever dissolve a marriage after the will was made?
She did not, no.
Were any children born to or adopted by Mrs. Solis after the date of the will?
No, none.
And so, is it correct that Mrs. Solis's will names you, Diana H. Lowry, and your sister, Patricia L. Garcia, to serve as independent co-executors without bond?
Yes, it does.
Did Mrs. Solis devise or bequeath any interests in her estate to the state of Texas or
No.
any other state or governmental agency?
No, she did not.
Any charitable organizations?
No, she did not.
Okay. Does a necessity exist for the administration of this estate?
Yes, it does.
And has notice and citation been served and returned in the matter and for the period required by law?
Yes.
Did you previously sign a document titled Proof of Death and Other Facts?
I did.
And that has been filed with the court, correct?
Yes, it has.
Have you ever been convicted of a felony?
No, ma'am.
Is there any other reason why you would be disqualified from accepting letters testimony?
No.
Okay. Thank you, Mrs. Lowry. And I would now like to call Patricia Garcia.
Yes.
Go ahead.
Okay. Hello, Mrs. Garcia.
Hello.
Please state your name for the record.
Patricia Garcia.
And what is your relationship to the decedent, Diana Benavid Solis?
She was my mother.
And did you just hear everything that your sister Diana testified to regarding the details of her passing and her will and the application that was filed in this cause?
Yes, I did.
And do you agree with all of the testimony that she has given?
Yes.
Did you also previously sign a document titled Proof of Death and Other Facts that has also been filed with this court?
Yes, I did.
Have you ever been convicted of a felony?
No, I have not.
And is there any other reason why you would be disqualified from accepting letters testimony?
No.
Okay, thank you very much. Pass the witness, Your Honor.
Any other witnesses or arguments?
No, Your Honor.
Ms. Lori, Ms. Garcia, in your mother's case, cause number 2026 PB 735L2, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider admitting your mother's will into probate. The court finds that she passed away, unfortunately, on the 9th day of April 2026 in Laredo, Webb County, Texas, having left a valid, executed, and unrevoked will dated May 29, 2015. The court finds that since that document was signed, no marriage was dissolved, no children were born or adopted. The court finds that there is a necessity to administer her estate. The court finds that in your mother's will, she did not name the state of Texas, nor did she name any charitable organization as devisees. The court finds that you are each and both qualified and you are not disqualified from serving. For all of these reasons, the court will grant your request, admit your mother's will into probate, and cause letters of testamentary to be issued out to you. The court has received, reviewed, and considered the order filed by your lawyer. It is in due form. I have signed it. I am tendering the original to the coordinator. The inventory on your mother's case is due to the court on or before September 17th at 9 a.m. Your lawyer will ask that you sign oaths, and those will be filed. Ms. Lori, do you have any questions for the court?
No, sir.
Ms. Garcia, do you have any questions for the court?
No, sir.
Anything else on this case, Ms. Dunn?
No, thank you, Your Honor. Good.
Ms. Lori, Ms. Garcia, I wish you both well, and you have the court's sincere condolences. Have a good day.
Thank you very much.
Thank you.
Thank you, Your Honor. May we be excused?
Yes, good luck to all.
Thank you.
Next online is Counsel Glenn Terrones, page 5, number 12.
This is the estate of Oscar Juarez, cause number 2025 PB 78602. Good afternoon, counsel.
Good afternoon, Your Honor.
Welcome to court, Mr. Terrones, the court martial president. You're participating by video conference. Gloria Juarez, are you present? Please step forward. As Ms. Juarez comes forward, are there any other persons present on this case?
Not that I know of, Your Honor.
Speak into the microphone, Ms. Juarez, and tell the court, are you Gloria Juarez?
Yes, I am Gloria Juarez.
Welcome to court, Ms. Juarez. As you can see and hear from this screen, your lawyer is present and participating by video conference. Counsel, what is the announcement?
We're seeking appointment of the executor in this case, Your Honor.
And is Ms. Juarez your only witness?
Yes, she is.
Ms. Juarez, I'm going to ask that you raise your right hand, please. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God? Court has heard yes. You may lower your hand. Mr. Terrones, go ahead.
Thank you, Your Honor. Ms. Juarez, what is your relationship to the decedent in this matter, Oscar Juarez?
He was my husband.
Okay, and to your knowledge, did he sign and execute a valid will on or about October 5th, 2017?
Yes, he did.
And to your knowledge, has that will been filed with the court?
Yes, it has.
And are you familiar with the will?
Yes, I am.
Okay, to your knowledge, did Article 5 of the will nominate you as executor and administrator of Oscar Juarez's estate?
I'm sorry, I didn't hear the question.
I said, to your knowledge, did Article 5 of the will nominate you to be the executor of Oscar Juarez's estate?
Yes, it does.
Okay, and to your knowledge, were the assets to be probated in this court in Oscar Juarez's estate in excess of $500,000?
No.
Okay, can you estimate what the assets are worth?
Let me answer that. Let me answer that question again. Yes, it might be more than 500,000.
Yeah, we're not entirely certain, Your Honor.
I'm not sure.
Yes. And can you tell the court the date of your husband's death?
Yes, he passed away on January 22nd, 2023.
And in what city did he reside at the time of his death?
Laredo, Texas.
And were you still married at the time?
Yes.
Okay, and since that will was executed, to your knowledge, has it ever been revoked?
No.
To your knowledge, did Oscar Juarez ever have any other children or adopt any children after the will was executed?
No.
To your knowledge, has any government agency or the state of Texas named as a devisee or heir to this will?
No.
Was any charitable organization named as a devisee or beneficiary of this will?
No.
Okay. And to your knowledge, did Article 5 of the will indicate that you were to serve as executor of this estate without bond?
Yes.
At the time of his death and to the present day, did Oscar Juarez have any debts to your knowledge?
No. The debts he had have already been paid.
Okay. And have you ever been convicted of a felony?
No.
Other crimes of moral turpitude?
No, sir.
Do you believe you're qualified to serve as executor of this estate?
I do.
Okay, and do you believe that this estate needs administration?
I do.
I have nothing further, Your Honor. I'd ask that the court take judicial notice of all the filings on it that have been submitted to the court thus far. In case I missed anything.
One thing, but I'll address that in 1 second. Ms. Juarez, in your husband's case, cause number 2025 PB 786L2, the court at this time finds that it has jurisdiction over your husband's case, meaning this is the proper court form and venue to consider admitting your husband's will into probate. The court finds that he passed away on the 22nd day of January 2023, having left a valid, executed, and unrevoked will dated October 5, 2017, as you've testified here today. Court finds that that will was never revoked. The court finds that he was married to you at the time, so no marriage was dissolved before his passing. The court finds that no children were born or were adopted after the execution of that will. The court finds that that will did not name the state of Texas or any state or any charitable organization as devisees. The court finds that you are qualified and you are not disqualified from serving. So the court grants your request, admits your husband will into probate, and will cause letters of testamentary to be issued out to you. Just one caveat, I'm going to have the orders on this case due honor before.
July 27th by submission.
Just file in orders, Mr. Terrones. I would sign the ones that you filed, but it lists a will dated November the 4th, 2014. I think that's a typo.
Yes.
So just file those in as soon as they get, you don't have to wait till then, Mr. Terrones. As soon as they get filed, as long as that correction is made, I will sign off on them as soon as they are filed. The inventory on your husband's case is due on September 17 at 9 a.m.
Thank you, Your Honor.
Is there an oath that Ms. Juarez can file?
Yes, Your Honor, there is an oath and it's ready to be executed by Ms. Juarez.
Go ahead and sign that so that it can get filed right now, please.
Are we excused, Your Honor?
No, not yet. Your client is signing the oath.
Oh, I can't see.
All right, Ms. Juarez, do you have any questions for the court?
No, sir.
I wish you well and you have the court's sincere condolences.
Thank you.
Have a good day. Mr. Terrones, good to see you. Have a great one.
Nice to meet you, Judge.
Thank you. Likewise.
Next online is counsel Alan Scheibel, page 8, number 21.
Holly Leasing Corporation versus RS Transport Services LLC, cause number 2025 CPK 1982C3. Good afternoon, Mr. Seinthal.
Good afternoon, Your Honor.
Court marks you present by video conference. Anybody here on behalf of RS Transportation Services LLC? Court finds no persons are present. Counsel, what is the announcement?
Just to change the pace, Your Honor, no probate matter here for a change, although you're really good and efficient at it.
I appreciate that.
What we have here is a post-judgment application for turnover and for appointment of a receiver. We obtained a judgment in this court on February 5 of 2026 and recovered a judgment for $74,731.64 with interest. After the date of that, I entered into an agreement with the defendants and they made 2 payments. They went into default. So I sent out a writ of execution, which came back nulla bona by the constable. I sent out post-judgment discovery, including admissions. In those admissions, the defendants admitted that they had non-exempt assets subject to execution. We are requesting the court under section 31002 of the Remedies Code for an order of turnover and for appointment of a receiver. Using the courtreceivers.com. They're a group based out of Dallas, have offices in some other cities. And I have submitted an order, a long order, asking for the turnover relief within the order.
Well taken on all fronts, Mr. Scheinthal, in cause number 2000. Anything else that you want to add on the record?
No, sir.
Mr. Scheinthal, in this case, cause number 2025 CVK 1982C3, the court takes judicial notice of the entire case. While the court finds that there is an unsatisfied judgment of over $74,000, the court finds that there's a necessity for a receiver. The court finds that reasonable and necessary fees in this case are and include a contingency fee of 25%. The court, having taken judicial notice of the entire case file, including the application for turnover after judgment and for the appointment of receiver, finds that everything is well taken and it is all relief as requested is hereby granted.
Thank you, Your Honor.
The court is signing an order to that effect. And tendering that original signed order to the coordinator and clerk's office. Anything else on this case, counsel?
That will do it. I appreciate your time, Your Honor.
Yes, sir. Have a great day. Good to see
Thank
you.
you. Bye-bye.
Next online, case, Counsel Nathan 2, page 9.
This is case 22, Janelle Monique Paredes versus Edgar Martinez, cause number 2026 FLA 871C3. Court marks Mr. Chu present and participating by video conference. Mr. Jonathan Garcia Davalos present in person. Speak into the microphone and tell the court, are you Edgar Martinez?
Yes, sir.
Welcome to court, Mr. Martinez. The court marks you present in person. The person to your right is your lawyer. Are you Janelle Monique Paredes?
Yes.
Welcome to court. The court marks you present by video conference, as you can see and hear from your device. So is your lawyer. And the court marks Mr. Raul Gonzalez present by video conference. He's here on behalf of the Attorney General's office. This is temporary orders and an extended TRO. Counsel, what is the announcement?
Your Honor, we've come to an agreement, Your Honor.
Yes, that's correct, Judge.
And one of the things that we wanted to tell the court, that we would like to consolidate the child support case that was originally filed. It was actually in this court. It's under 2018 FLI 34C3.
Any objection? I guess this is your agreement. Confirm that agreement, Mr. Chu?
Yes, that's correct, Judge. We have no objection to consolidating the child support case into this case.
Any objection by the Attorney General's office, Mr. Gonzalez?
No, Your Honor.
All right, the consolidation is hereby granted then, and you're right, there's no need to transfer because it's in the same court. The consolidation order is due to the court honor before.
July 27th by submission.
All right, just file it before, I'll sign it before. Announcement as to these temporary orders and extended TRO.
Yes, Your Honor, we have agreed that it be a joint management conservatorship with the primary as to Ms. Paredes. And in terms of possession and access, since Mr. Edgar Martinez has a different type of work schedule, we will be asking that Mr. Edgar Martinez be allowed to have the children every weekend on the following the third Wednesday, starting from this Wednesday. So it will be on the third Wednesday. I know that it's sort of confusing, but it's the weekend on the third Wednesday, starting starting tomorrow on July 1st. And that's where the work schedule shows that he saw that whole week. So in theory, the way it would apply is that it will be the third Wednesday will be July 15, and so he will have possession of the children on that weekend of the weekend of that week, which is starting Friday, the 17th, and then 18th, and then returning the children on Sunday, July 19th. And it will be like that every weekend on the third week. Obviously, if there's an agreement among the parties, then it can be different. Absent an agreement of the parties. And then also, in terms of, regarding possession as well, that he be allowed to meet with the children during, daytime hours, reasonable hours when he's off at the home. Which, can you please give the address of the home?
3716 Bay Street.
Okay, as to that residence, it has to do in connection with that is that, Ms. Perez is asking that she have, access, that she have, exclusive use and possession of the house. And for that to take effect, after July 20th. And so that he'll be allowed to go to the home so that he'll be able to get his belongings and so forth. And I give, I don't know, basically for that to take effect after the 20th of July. After that day, then Ms. Paredes will have exclusive use and possession of the home. And so that he'll be able to go, on July 15th, during those days. And thereafter will be just simply to go to the home to see the children, and visit with the children if it's working among the parties. In addition to having the possession of the children. In terms of child support, Your Honor, we'll be asking that the court allow that the child support be suspended. And so therefore, the child support that is occurring right now under that case that has been consolidated, that it be suspended. And that will be an agreement among the parties in exchange that Mr. Martinez be paying the mortgage and also utilities. And to clarify, utility will be the light, the water bill, and internet services.
That's good.
Other than, and so besides that, in terms of the child support possession access, that will be taken care of. In terms of the properties, and he has, exclusive use and possession of his house, of his vehicle, and Ms. Paredes will have exclusive use and possession of the vehicle that is in for possession. Any other expenses will be as to their responsibilities. And in addition to that will be, I guess I'm not, I think that will be covering all the other things. I don't know, Mr. Chu, whether you have any other issues that you would like to address.
Just to be clear, Judge, visits on the house, that's gonna be about 2 hours. If he wants to spend the whole weekend, then he can take the children to his parents' house. He just needs to give my client notice.
Mr. Chu,
About
so that the agreement is binding and enforceable, how much notice do you believe would be reasonable and necessary?
About 24 hours notice, Judge.
Any objection to 24-hour notice?
No, that will be fine, and that's the understanding that Mr. Martinez will be taking the children on the weekends, to his parents' house, basically not the Vela residence where Ms. Paredes is residing now.
All right.
He's fully aware of that.
Mr. Paredes, excuse me, Ms. Paredes, Mr. Martinez, would you both raise your right hands? Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Both have answered yes. You may lower your hands. Let me start with you, Ms. Paredes, because you're the petitioner. Is your true and correct name Janelle Monique Paredes?
Correct.
One more time, you're joining us by video conference, as is your lawyer, Ms. Paredes. Did you hear and understand the agreement that was told to the court by the lawyers?
Yes.
Is that your agreement with Mr. Martinez?
Yes.
Is that your full agreement?
Yes.
Was anything left out?
No.
Is there anything you want to change?
No.
Do you believe that this agreement is in the best interest of your children?
Yes.
Same questions to you, Mr. Martinez. Is your true and correct name Edgar Martinez?
Yes, sir.
Mr. Martinez, you're joining us live in person. The person to your right is your lawyer, Mr. Martinez. Did you hear and understand the agreement that was told to the court by the lawyers?
Yes, sir.
Is that your agreement with Ms. Paredes?
Correct.
Is that your full agreement? That's right. Was anything left out?
No, sir.
Is there anything you want to change?
No, sir.
Do you believe that this agreement is in the best interest of your children?
Yes, sir.
The court hereby adopts and approves your agreement, find that it is in
Your-
fact in their best.
Your Honor. Your Honor, the OIG.
Mr.
apologize.
Gonzalez, I apologize. Go ahead.
I was just gonna ask the parties if, regarding medical support or health insurance, Your Honor, what do they have? In the previous order, medical insurance was $150 through the government program. That is a 2018 order. I'm not sure if the parties are carrying their whole own insurance right now, or if we're gonna continue carrying it through the government program.
Mr. Garcia,
Good.
Mr. Chu, who has the answer?
We can keep it the same, Judge, with the government program, and then Mr. Martinez reimburse.
All right.
I'll see if I can do it through my job and head that route. Yes, and my understanding is that's correct. That is basically reimbursing $150, but my understanding is Martinez may have through his employment medical insurance, so he may upon giving notice to the AGs and the parties, if that is something that is available, you'll go ahead and proceed with that.
I think that would be good and in your children's best interest. So ordered. These are only temporary orders because we're coming back for a final hearing on September the 1st at 2 p.m. But these temporary orders are due to the court honor before
July 29th.
Yeah.
All right. So as soon as they come in, I will sign off on them. Anything else on this case, Mr. Garcia Davalos?
Yes, Your Honor, I completely, Mr. Chu and I discussed also having to do with the home. We agreed that the home be placed on sale after giving Ms. Paredes around 2 months for her to be able to refinance and put it on her her name. But if she's not able to, then the parties will agree to put the home on sale for after the 2-month window period. Your Honor.
Is that the agreement, Mr. Chu?
That is correct, Judge.
Well, 2 months puts you a few days right before your final hearing. So if there's any issues, just come back and present whatever information you need to so the court can grant the appropriate relief. Well taken. All right. Mr. Martinez, do you have any questions for the court?
No, sir.
Ms. Paredes, do you have any questions?
No, sir.
Anything else from any lawyer?
We rest, Judge. Thank you.
Your Honor, orders due was July 27th. My mistake.
So ordered July 27th at noon by submission. Ms. Paredes, Mr. Martinez, keep in contact with your lawyers. I wish you well.
Thank you.
Mr. Chu, Mr. Garcia Davalos, Mr. Gonzalez, good to see you all. Have a great day.
Thank you, Judge. Bye-bye.
Next online is Counsel Silverio Martinez, page 3, number 7.
Page 3.
Mendoza Maintenance Group.
Did you say page? Oh, I apologize. You are absolutely right. Page 3, number 7, Mendoza Maintenance Group, Inc. versus Arturo Mendoza, cause number 2025, CVD 88L2. Good afternoon, Mr. Martinez.
Good afternoon, Your Honor.
Court martial present, you're participating by video conference. Who is the other person with you, Mr. Martinez? Is this your client?
Is he there? Yes, he's there.
Oh, I see. Please step forward. I was asking you the other person in the room with you.
Oh, no, I'm sorry, Judge. No, I was sorry. I was in federal court and I could not be there in person, but my client is there.
One more time. Who is the person in back?
Oh, I'm sorry. He's a law clerk. He's a law student, Judge. I apologize for that.
I just wanted to
Yeah.
make sure he wasn't a party, a witness, or anybody that we needed to put on the record. Very good.
No. He's just he's a law student. He works at the office here. Apologize.
Understood. Tell the court your name, please.
Hime Mendoza.
Mr. Mendoza, welcome to court. The court martial present by video conference. As you can see, your lawyer is present by video conference. And your name, please.
Margarita G. Mendoza.
Ms. Mendoza, welcome to court. The court martial present in person as well. And Arturo Mendoza, are you present?
I think he's outside.
Yes, please. Mr. Mendoza and Ms. Mendoza are both present in person. Their lawyer is present by video conference. Arturo Mendoza is not present, but for the record, our bailiff has gone to see if he is present and outside the courtroom. Mr. Mendoza, please step in front of a microphone, pull it as close to your mouth as possible, and tell the court, are you Arturo Mendoza?
Yes, sir.
Welcome to court, Mr. Mendoza. The court marks you present in person. Mr. Mendoza, you were self-represented at the last hearing, meaning you didn't have a lawyer. Is that still the case?
Yes, sir.
Court marks you self-represented once more. Mr. Martinez, what is the announcement?
Your Honor, this is an appeal that was filed out of a forcible detainer action concerning the immediate possession of the residential premises located at 8519 Michigan Avenue upstairs. That's here in Laredo, Texas, Your Honor. This appeal is an attempt to defeat the court's jurisdiction by saying or trying to convert this into an ownership claim, which would require us to go to district court. I'm sorry, not district court. That would take it out of the JP court, which is the underlying order ordering his eviction. So bottom line is the relevant inquiry really is whether the issue of immediate possession. And I'm suggesting to the court that issue is still the only issue at hand. And if anything needed to be done with regard to ownership, that needs to be filed separately, which we're filing a motion, a separate lawsuit in the district court for declaratory judgment on the ownership of the property, Your Honor, and to remove the cloud. So at this point, the only issue is whether this court should divest itself of jurisdiction because of the ownership issue. And the answer to that, I would suggest to the court, is no, it should not. The court should maintain jurisdiction, and the court should order as had been ordered or affirm the order of the underlying case.
I guess I'm confused, Mr. Martinez, and I'm pulling up the case file right now, but is there a pleading or request for affirmative relief with regard to ownership?
There is
Or a plea to the jurisdiction by a party?
No, Your Honor.
So if there isn't a plea to the jurisdiction, if nobody's claiming that, then ostensibly Mendoza maintenance, one at the JP level, it's being appealed by Arturo Mendoza. So the burden as in a trial de novo reverts back to Mendoza maintenance. If in fact the court hears evidence and testimony that the plaintiff doesn't own the property, then the request is denied and there's no jurisdictional issue. It's just they don't have the superior right to possession, like you said. But if they prove their case, then Mendoza maintenance as the owners get possession.
Correct.
Have I misstated any legal facts?
No, that's pretty much it.
All right. I can't pull up the case. Give me 1 second. But just to confirm, I guess let me ask the clerk's office to confirm. There is no request for divestment of jurisdiction, right? No plea to the jurisdiction or anything of the sort?
No, Your Honor, it was just a writ of possession that was issued.
Right. Yeah, because at this hearing, anybody can claim that they don't own it or they do own it, but then that just becomes a matter of the court affirming the ownership or denying ownership, and then the case is dismissed if that's the case. I have reviewed the case file. There is no plea to the jurisdiction. All right, Mr. Martinez, are you ready to go forward?
Yes, Your Honor. Is there a way I could go there in person, Your Honor? I'm a block away. I don't know if it's closed already, but I would prefer to be there in person. If the court can put us for reset us for a few minutes.
I will place your case on as the second. Let me ask you. Well, no, it's a trial de novo. So even if there's an agreement, you still have to prove your case. But let me ask you this, Mr. Mendoza, will you be contesting Mendoza Maintenance Group's possession? All right. So this is the second contested matter on the court's docket today. Stand by, please. Stand by. I'm going to call your case momentarily.
Great. I'll be right over.
Thank you, Mr. Martinez. Have the cases to all persons present been called?
I'm not sure if the people in the public are.
Your Honor, Victor Villafranca, I'm present.
Page 1, case 2 in the estate of Flavio Zapata, cause number 2019 PB 41302. Court marks Mr. Victor Villafranca present by video conference. Good afternoon, counsel.
Good afternoon, Your Honor.
Rebecca Zapata, are you present? Are you Rebecca Zapata?
Your Honor, I was appointed ad litem to the heirs judge. One of the heirs approached me and asked me, since she's 18 now and she's present there with the court, to release funds since she's of age now. Your Honor, I believe that was one of the terms of the settlement. The monies are already in the court's registry. My client is in front here, Judge, and she's requesting the court to release funds that I believe she was entitled to, Your Honor.
I recall this case, Mr. Villafranca. I think I might have granted it outright, except for one thing. In review of the case file, Mr. Villafranca, there is only an assertion that Romina Zapata has turned 18. I mean, if it's there, I couldn't find an affidavit, a statement, verified anything. I think that's the only question the court has. Ms. Zapata, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth to help you God? You may lower your hand, Mr. Villafranca.
Can you please state your name for the record?
Romina Zapata,
Ms. Zapata, how old are you?
18,
What day were you born?
March 18, 2008.
When did you turn 18?
March 18, 2026.
Okay. Your Honor, that's all we have. My client's 18. I appreciate it, Your Honor.
Yes, sir. Ms. Zapata, I find that you are now an adult and entitled to release of the funds. The court hereby grants a request and will the court has signed an order to release the amount of $37,500 to you with a 5% administrative fee of no more than $50 paid to the clerk's office. Your request is very well taken. I've signed an order to that effect and tendering the original copy to the clerk's office. Do you have any questions for the court, Ms. Zapata? I wish you all the best. Have a great day. Any other cases for Mr. Villafranca?
No, Your Honor.
It's good to see you, counsel. Have a
Thank
good
you,
one.
Judge. I'm excused.
Yes, sir.
Thank you.
Case 1, Portfolio Recovery Associates LLC versus Brenda Almanza, cause number 2018 CBF 5902. Jesse Lockhart, are you present?
Not present.
Court will take that under review by submission. If everything is in the court file that should, I will sign it. If there isn't, I will dismiss this case for warrant of prosecution. Court has called all the cases on today's docket. We'll start with the first contested matter on the court's docket. Page 3, case 5, the estate of Maria Guadalupe Lopez versus, in the estate of Maria Guadalupe Lopez. Cause number 2022 PP 4109L2. Court marks Ms. Soto present in person, Mr. Jonathan Garcia Davalos present in person, attorneys Jose Luis Castillo, Olivero Canales. Any other lawyers present? Court finds no other lawyers are present. Any parties present?
Yes,
Yeah.
ma'am.
Yes.
My client is the applicant in this objection also filed is Ms. Reyes, Maria Guadalupe de Reyes.
Is she present?
Yes.
Court martial present and Patricia Garcia as well.
Would the court want her to come over here?
It depends. What is the announcement, counsel?
Well, Your Honor, we filed an objection to the proposed order and also an application for sale of the state property, which is a property that the court had made an order as to the distribution. So if the court were to entertain our objection, And also the filing, I filed also a motion for new trial based on the fact that the court issued out the order. So the court will have and retain jurisdiction as to that issue.
And in brief response, Your Honor, so I did get a copy of those pleadings. I believe at this point, since there's a motion for a new trial that's been filed, the objection would be if I erroneously added something that the court did not rule or that the parties did not state on the record that they agreed on. And it does follow the agreement read into the record. So I would ask that instead of duplicating testimony, because it is going to require testimony or an evidentiary hearing, that the objection be heard alongside with the motion to transfer, for new trial hearing.
Well, I think I can, here's what I think should happen, then I'll hear from each of you. So let's take care of the objection first. Mr. Garcia Davalos, ostensibly you filed the objection because you received and reviewed the proposed order filed by Ms. Soto.
Yes.
What in the proposed order is different from what the court pronounced and rendered on the date of the final hearing?
As to the order, Your Honor, my understanding is that my client was not in agreement, and that in the order it is found that the distribution is not a fair and equal distribution. And so in conjunction with my objection, I added my application for sale of the real estate property, in which the code guides the court that if it finds that the distribution of the distribution of the real estate property will require the sale. In other words, it cannot be just simply be given out in equal shares, then it will require that it be sold. Under the
Recording in progress.
Under section 360.201, which is a partition and distribution of state property is incapable of division. And so the distribution that is being done in that order is not fair and equal among the heirs. And because it involves 3 lots, and each of the lots are different and cannot be basically given in the way that they're being distributed. There's some sort of payment plan that they were making that is not equitable to the party receiving the monies. Whereas in my client's view, the person who's receiving the properties are advantageously taking more than what she's paying out to the other heirs.
So I guess the question the court has is, on April the 7th of this year, the court had a hearing. Ms. Soto was present. The dependent administrator was present. Roberto, Rolando, Lopez, and Maria Guadalupe Reyes were present. No other persons were present. And I guess the court either heard evidence, testimony, heard argument, or the docket sheet isn't clear. Oh, no, I did hear testimony. Two persons were sworn in. An agreement with regard to the distribution of certain lots and properties was read into the record, and then the court approved it since it was by agreement. And I guess the first question the court has is, is the proposed order a true and correct rendition of what was the outcome on April the 7th? In other words, did the order that the court signed on June the 15th of 2026 do anything different than what was ordered and approved in court on April the 7th, 2026? And if so, what was different?
My understanding is that upon meeting with my client is that they were not in agreement, so it may, I mean, and so this is where I may have to require that that I get a transcript of the hearing. And therefore, you know, that's the only thing I can ask the court to reconsider. I understand what the.
That's a different request, and I think that's ultimately going to be the court's notation. So if there isn't anything specific, any specific provision in the order approving the distribution that is different than what happened in court, then the objection should be denied. You still have the opportunity to file a reconsideration, and you have filed a motion for new trial in any event, and I can set that for hearing now within the court's plenary jurisdiction.
I mean, my motion for new trial still allows, I mean, it basically opened up the ability to have given the court the jurisdiction.
I think that's right, but for an objection to be sustained on a signed order or a not yet signed order is the party has to be able to specifically point out a provision in the proposed order that doesn't conform to what happened at the last court hearing. And if there isn't, and it's okay, I mean, the proposed order could be absolutely right, but if I got it wrong on the law or counsel got it wrong, then that motion for new trial would be the appropriate avenue or reconsideration, either one, but you filed one of the two, so I think your client's rights are protected. Ms. Soto?
That's what I had mentioned to the court. I think that it should go forward with a motion for new trial and allow me to respond to that and present my argument to the court. Because my recollection was there was testimony from two parties. Oh, well, the dependent administrator, one of the heirs, and Ms. Maria Guadalupe Reyes did not provide testimony, but the court did bring her up to the bench, and she did state on the record that she had heard the agreement as read into the record and that she agreed.
I'm gonna do some quick math in my head. So let's do this. If the movement can't point to any specific language in the signed order, then the objection to that order is hereby denied without prejudice. So you can bring it back at any time and just point out to the court what it is that you think I got wrong. And then we'll set the motion for new trial on a date within the court's plenary power jurisdiction, which I believe is 75 days from the date I signed the order. Any disagreement with any of this as a matter of law, Ms. Soto?
No, Your Honor.
No, Your Honor.
All right. There being no objection, I have to have a hearing 75 days before 75 days of June 15th. Give us a setting. Now, let me see. If my math is right, and you all need to check me, or my calendaring is right, then we need to have a hearing before August 29th. Any different calculation of dates by either lawyer?
I'm checking, Judge. That's correct, around before August 29th.
I mean, I have 75 days from June 8th, which is when the court signed the order, is August 22nd. August 22nd.
Yikes, I'm glad you caught that. Wait a minute, it was filed the 15th. When did the court sign it? You're right. You're absolutely right. It's June the 8th. It has an entry date of the 15th, but it was signed on the 8th, so the 8th is the date that prevails. So that's why I ask August 22nd. Give me one second. So let's just make a notation in your calendar on August the 6th. We need to move that date. So let's do this. Let me set the motion for new trial for hearing on August the 18th at 2 p.m. But just pre-file your orders granting the motion for new trial and denying the motion for new trial, because what I don't want to happen is I set it for orders due, and then I'm going to lose plenary jurisdiction, plenary power before even signing an order. So just bring them in or file them into the case. That way I make a decision and I sign one or the other.
Yeah, and if the court can also set for that day, because I did file an objection and also an application for sale of the real estate property, which if the court were to reconsider the order, it would allow the court to move on the application for sale of the real estate property.
You filed an objections separate and apart from the proposed order?
Because they're both together, but they're separate within and I paid for the application piece, so I don't want to pay for another application.
An application for sale, I see that. Okay. So Ms. Soto, file an order denying the objection, but the court will hear both the application for the sale and the motion for new trial on August the 18th. Thoughts, comments, questions, or objections, Mr. Garcia-Davalos?
No, Your Honor.
Ms. Soto?
No, Your Honor.
All right. Anything pending on this case then, Ms. Soto?
Those are the only matters before the court today, Your Honor.
Mr. Garcia-Davalos?
No, that will be all, Your Honor. So August what?
18.
August 18th.
All right. I look forward to concluding this case. It's good to see you, Mr. Garcia-Davalos. It's good to see you, Ms. Soto.
Thank you, Judge.
Have a great day.
Your Honor, the order on the objection denied without prejudice,
Is due honor before?
July 27th.
So ordered. Thank you for that, Ms. Rodriguez. All right. That leaves one contested matter before the court. Is that right, Ms. Rodriguez?
Yes.
All right.
3 number 7.
Last case on the court's docket, Mendoza Maintenance Group, Inc. versus Arturo Mendoza, cause number 2025 CVD 8802. Court marks Mr. Silverio Martinez present in person, Mr. Jaime Mendoza present in person, Ms. Margarita Mendoza present in person, and Mr. Arturo Mendoza is also present in person.
Good. Okay.
Give me 1 second so that everybody's present before you say anything. Yes, looking for, please call in Mr. Martinez and Mr. Mendoza.
Attorney.
Give me 1 second while I just want to make sure that everybody's present before you start communicating with the court. Court marks all persons present on this case as noted on the record. Mr. Martinez, what is the announcement?
We're ready to proceed, Your Honor.
All right, and before court has heard from counsel that he is ready to proceed, Before you walked in, Mr. Martinez, Mr. Mendoza wanted to make a statement. I said pause so that everybody's present. Mr. Mendoza, what is it you were wanting to tell the court?
Well, actually, the original owner of that property, and I gave power of attorney to my brother, which I never thought for him to kick me out of my own property, by giving him power of attorney. I mean, he just, throw me out to the street like that.
I mean, if
This is the case where I made a mistake. I made a mistake by giving him power of attorney because I thought he was my brother. I give him power of attorney, so if something happens to me, he has the property taken care of. But I never gave him power of attorney for him to kick me out of my own property.
I believe that's the reason we're here, and
Right.
I don't want you to say anything that could. I mean, I guess you don't have a choice. Whatever you're going to say is going to help or hurt your case. But I mean, if all that is true and correct, Mr. Mendoza, then we're talking about two different things. If you're saying that your brother has legal authority to quote unquote, as you've said, to kick you out, then he has the legal authority to do that. Now, if your question is whether he has the moral responsibility to do something different, that's not. I can't answer that question. I must stick to my lane, and the only thing I do here is determine who, in fact, has the superior right of possession. Do you understand this? We're talking about two different things. I think you're talking about some moral obligation to do something or not do something, and the only thing I'm going to do here is just determine as a matter of law whether the person or entity that has the superior right to possess the premises that are at issue in this case has the right to do so or doesn't have the right to do so. I'm not going to answer any questions of moral obligations or responsibilities. And I just want to make that clear. If that answers your question, Mr. Mendoza.
I guess.
All right. Mr. Martinez, how many witnesses do you have? Just these two witnesses? All right, then I'm comfortable with leaving everybody here. I just need everyone to have their own microphone so that everybody can speak clearly into the record. Then Mr. Mendoza and Ms. Mendoza, I'm going to ask that you three raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
All have answered yes. You may lower your hands. Mr. Martinez, who is your first witness?
We'll call Mr. Hime Mendoza.
Go ahead.
Can you state your name, sir, for the record?
Hime Mendoza.
Mr. Mendoza, you are the respondent in this case, the plaintiff in the underlying JP case, correct?
Yes, sir.
And you filed it as Mendoza Maintenance Group, Inc. Are you the owner of that company?
Yes, sir. 100%.
And you filed this lawsuit in the JP court asking for possession only of the property located 5303
85.
Oh, I'm sorry.
Excuse me, into the record.
Can you say that again, the address?
8519 Michigan Avenue in Laredo, Texas.
Correct, I have it here. Okay, rear upstairs unit.
Yes, sir.
Okay. And at the time of the eviction, you presented a proof of ownership. Is that correct?
Yes, sir.
And I'm gonna show you.
Well, have you uploaded these into Case Center?
That's why I wanted to be here in person.
So you can. I haven't done that in like 8 years, 5 years, 6 years, 8 years. I don't know. I don't remember the last time we did that.
They are part of the appellate record.
Why don't you do that instead?
I'll refer to it as that.
Let's do that. If you need something prompted, just tell the court staff to prompt based on the records that are already on file.
I'm gonna show you what has in the appellate record. The two it is, it's entitled warrant to use document. I think it's 844435. Oh, I'm sorry, I'll just put it, make sure I speak into this. Do you recognize that document?
Yes,
And that is entitled warranty deed, correct?
yes.
And what property is being conveyed via that document?
The lot 8519 Michigan Avenue, Laredo, Texas.
And who is conveying it to whom?
Arturo Mendoza Jr. conveyed it to to Mendoza Maintenance Group.
Okay. Particularly Hime Mendoza,
Yes.
Mendoza Maintenance Group, is that correct?
Yes,
And so I'd ask the court to take judicial notice of that document in the appellate record.
Court takes notice that that document is pages 8 and 9 of the appellate record. Notice so taken.
And in the JP court, did she submit that to the court for consideration?
yes,
And did the judge accept it as evidence in that case?
yes.
Now, is there any other document conveying that property to anybody else that is right now effective in the real property records of Webb County?
No,
So that property belongs to you or to Mendoza
yes,
Maintenance? Okay. And it has not been conveyed, like you said.
correct.
And based on this, at some point in the past, did you allow your brother, the appellant in this particular case, Arturo Mendoza Jr., to live there?
Yes,
And was he paying rent?
never.
And was that the agreement?
Yes,
Nevertheless, at some point you asked him to leave.
he's been asked to leave multiple. He's within the last 20 years, he's left. He's come back. He's left, and now he doesn't want to leave. He wants to die there, I guess.
Okay. And so you've told us the status of the property and the ownership. Just to give the court a little short, brief background. Who is Mr. Arturo Mendoza of yours?
He's my older brother.
And he mentioned earlier something about a power of attorney. Do you have a power of attorney over him?
Yes,
And why do you have a power of attorney over him?
because in 2002, he was run over by a police officer of city of Laredo. And I settled with the city for a settlement of $250,000, which was the maximum allowed by law. And my brother, my whole family got together. We had an agreement with my older brother, because he is a drug addict. He currently continues to be a drug addict and a sex addict, that I would manage his money and I would not take anything from him, since I'm not getting an attorney involved. I told him if he stays off drugs, I'll help him out and I'll manage his money. He won't have to worry about anything.
So you agree to manage his money, and you also agree to allow him to live there for free, basically.
As long as he stayed off drugs and he was a productive, just a good person.
Okay. And did he do that for a while?
No,
And is this the reason that you eventually asked them to leave?
we've asked him, yes, many times.
Have you tried to help him with regard to his addiction,
Yes, many times.
and to no avail?
He refuses. He'll get help. A lot of times he'll go to jail for a year or two. He'll come back sober. He'll be good for a year or two. And then he just goes back he always goes back to the drugs, but then it just consumes him after so much time.
And has he had other legal or other issues, for example, legal, as opposed to just drug addiction?
Yes, he steals. I think prostitution, he has a rap sheet maybe 40 pages long.
And did that ever jeopardize this property or any other properties?
Yes,
And hence the reason you are his caretaker.
correct.
So as far as now that you gave the court a little background, you've established via this document, again, referring to pages 8 and 9 of the appellate record, Your Honor, that you are the owner of that property. You're asking the court to affirm the justice of the peace's or justice of the peace court decision or order evicting him from the property.
Correct.
That's all I have from him, Your Honor. I'll pass the witness, and if no questions, I would put on the second.
Mr. Arturo Mendoza, do you have any questions for Mr. A. Jaime Mendoza? This is your opportunity to cross-examine. That's to ask Mr. Mendoza some questions. Do you have any questions for him?
Yes, he took care of my money. Gave him power of attorney, the property and the
Objection, Your Honor, to
check
question and answer
with,
format.
The objection is sustained. Mr. Mendoza. Mr. Mendoza, you're allowed to ask Mr. Jaime Mendoza a question. What is your question?
Did you ever give me any part of that money, that 250,000 I gave you, saying over to you?
Objection, Your Honor, relevance.
What is the relevance to the question, Mr. Mendoza?
I don't know, I don't hear most of the stuff.
Hmm.
And when you said something about contempt or something before he got here, and you know what that means, I even told
I
you.
haven't used the word contempt.
Or-
Not
I
the
don't know if
day.
you said it was
Go ahead and answer the question. I am going to overrule the objection since
I just want to
Mr.
have a jury.
Give me 1 second. Mr. Jaime Mendoza did testify that no rent was paid. To the extent that that answers that, you can answer the question, his question.
From the $250,000 judgment, I believe he spent about 160,000 of it, 80,000 of which he bounced. There is the last 60,000 that he had so exclusive from the checking account. I separated myself once he was past help. I told him, Aruro, I'm no longer going to help you. Here's a checking account. I'm not authorized to sign it. I still had the power of attorney. I told him, here's 60 or 80,000, Judge. And I told him, you can revoke my power of attorney. You can do whatever you want. Here's your $60,000. This is after paying for he spent a lot of money. 60,000 was left. I kept about 80,000 because the agreement was, if he goes back on drugs, then I'll give him his portion. And since I acted as his attorney, I'm going to keep the 35-40%, which is what we did, which is what the whole family did. The whole family had to settle with the city of Laredo. It wasn't just my older brother. It wasn't just me, but the whole family had to sign that we were not going to go after the city. We signed a lot of NDRs, and we signed a settlement. I think it was like 40, 50 pages long. So yes, he did get his money back. You did get your money back.
Do you have any other questions for Mr. Mendoza?
Only got 60,000. He wrote a check for 60,000. That was it.
Any questions? Any other questions for him?
Can't believe you're kicking me out on my.
Court has heard no other questions.
you
Any?
go
No, ma'am. Let me hear from Mr. Martinez. Who is your next witness?
Miss, can you say
Margie Mendoza.
Mendoza, Martin Mendoza.
Go ahead.
It's gonna have to be on a question and answer. I know you want to say whatever you want to say, but let me ask you questions and then you can elaborate. Okay. Can you state your name, full name for the record?
Margie, I'm known by Margie Guerra Mendoza, but my official name is Margarita G. Mendoza.
And Ms. Mendoza, how are you related to these two gentlemen here?
They're my sons.
Both of them?
Yes.
Okay. And you heard the testimony that Mr. Jaime Mendoza gave today.
Yeah.
Do you disagree with any of it?
Nothing. Everything's true.
Okay. And do you agree that that property does in fact belong to Mr. Jaime Mendoza or Mendoza Maintenance Group?
Yes.
Okay. And do you believe that if Mr. Jaime Mendoza would not have controlled the money as he explained to the court, it would have affected him, Arturo, negatively
Definitely,
because of what?
because from the very beginning, he started giving money to his sex girls and other friends, and he would always constantly be attending Exotica and living the rich guy life. He never gave me a penny. I was there from the day that he had the accident. He was flown. That same night I went over, I stayed there until he was released. I take him home. I'm taking care of him for rehab. He stopped wanting to, because he's very stubborn. He wanted to stop doing rehab. And that's where I drew the line. I said,
And let
okay,
me interrupt you there so we don't go too
Yeah.
far into the details, but the rehab was for what? Drug addiction?
no, for his
The
body,
leg.
because he almost lost his leg.
And how about the drug addiction? Has that been a problem?
Oh, constantly. Even when he was at home, I didn't know this, but he was doing drugs.
Okay, and you heard what Mr. Mendoza said. The agreement was if he would stay off the drugs, which is in his best interest, he would be able to keep the money,
Yeah.
correct? And he didn't.
Mm.
Is that a no?
He didn't do it.
He didn't stay off the drugs. Okay, so just to circle back around, with regard to this property and the document that I've submitted here to the court or pointed out to the court, it's already in the appellate record. As I think 8 and 9 of the appellate record. Do you agree with Mr. Mendoza's characterization of the ownership of that property, that property has in fact been conveyed to Mendoza Maintenance Group and remains in the ownership of Mendoza Maintenance Group? Is that your opinion as well?
Yes, especially because he never paid taxes, so they were gonna foreclose. And that's when, he
Which is one of the questions I asked. I mean, aside from the fact that he had drug addiction issues and other issues that you mentioned, did he have any legal issues that at any point in time jeopardized this property?
Oh, definitely, because he was in and out of jail constantly.
Okay. And so at this point, do you agree that he needs to be evicted, or are you also in agreement that he should be evicted based on his one, lack of payment of rent, and 2, lack of keeping the agreement with Mr. Hime Mendoza, and 3, putting the property at risk?
Definitely, he'd been given so many chances that at one time, about 10 years ago, I, the mother, told both my sons not to help him anymore, and you know what they answered? They answered, Mom, but he's still a brother. I felt ashamed,
Yeah.
but he only threatens us. He's accused them that they killed his father recently. I mean, like, he's totally out of control. He's not grateful. He's not a family man. He's never been in our family. Never called me other than to ask for money or to ask for food. That's all he is. I mean, I just pray and hope that justice will be done, because he's constantly threatening us, even myself. He
I got
sent me a horrible video, which that's when I blocked him, because it was really, really bad.
Okay, Ms. Mendoza, thank you very much. I'll pass the witness.
Mr. Arturo Mendoza, do you have any questions for Ms. Margarita Mendoza? This is the one opportunity you'll have an opportunity to ask questions. You can use that time or not use that. It's up to you.
I just can't believe what's both of them. I don't know,
Well, I understand that, but the only way that you can tell the court your story is through questions at this point. Do you have any questions for Ms. Mendoza?
no.
All right, Mr. Martinez, do you have any other witnesses?
No.
Mr. Arturo Mendoza, this is now your opportunity to say whatever you want to say. Is there anything that you want the court to know, or is there anything you want to put on the record?
I want to have a jury trial. And I want to have a lawyer, because I really don't understand most of the words you say. Earlier, before he got here, I just agreed to it. I'm not that right? That's why, that was one of the reasons I gave him power of attorney, because that way he could manage the money, pay the taxes and do whatever. And he just gave me 60,000, that was it. I mean, yes, I do believe that he had something to do with the murder of my father, because when I asked him for one day off from taking care of my dad, feeding him, cleaning him, so I would bathe him. I even have a video where he says, "Ya comí tu dad."
Objection, relevance.
And- and- and I have a
Sustained.
video that says he
Sustained.
that's in,
I find that anything that happens after that situation or anything related to that situation is not relevant to the merits of this
that
case.
lady
So
that used to take
let
care of my
me,
dad,
Mr. Mendoza,
the lady that used
tell the court only things that pertain to these premises. What do you want the court to know, if anything else?
why didn't you let any of my dad's friends or me go into the house? Nobody couldn't visit dad. Why? But you got mad because I didn't go to the funeral, but you took away the last few days of my dad.
Mr.
being
Martinez?
alive.
I'm gonna object, Your Honors, to the form.
Sustained. So I'm going to redivert the attention of this hearing to the reason we're here, and that's the ownership and possession of
Yeah,
this.
right after my dad dies,
Sir,
like,
when the judge speaks, you cannot speak over him. Wait for the judge to finish.
Mr. Mendoza, tell the court anything you want related to this
when
property.
my dad died, all the property, all the business, the equipment, never got divided up among us. He kept everything. He kept, why does he have the right to do that?
Anything else you
All the
want to,
property.
anything else you want to tell the court?
I want to have a jury trial.
Anything on cross-examination, Mr. Martinez?
No, Your Honor.
All right. Closing, Mr. Martinez.
Your Honor, we just asked the court to affirm the judgment of the Justice of the Peace by way of this appeal. I think we've submitted enough testimony as well as pointed out the documents in the file that show superior, not only superior right of possession, but as ownership as well. I think that that's been made clear not only by Mr. Hime Mendoza, my client in this particular case, but his mother as well, who is well acquainted with all the facts and the history of this case, and pretty much confirmed by Mr. Arturo Mendoza here today as well. So I'd ask the court to affirm the judgment, and additionally, we'd ask for a judgment, although we know it's not going to get paid for the unpaid rents.
All right. And your closing statement, would you like to give a closing statement, Mr. Arturo Mendoza?
I want to have a jury. 'Cause I need to have a lawyer because I really don't understand what's going on. And I gave him power of attorney to him, not to the person.
All right. In this case, Mendoza Maintenance Group, Inc. versus Arturo Mendoza, cause number 2025 CBD 88L2. The court finds that it has jurisdiction over this case, meaning this is the proper court form and venue to hold this this hearing on possession of this property and appeal from the appellate court, which is a trial de novo. The court finds that the true and correct owner of the property at issue in this case is Mendoza Maintenance Group, Inc. The court finds that sufficient evidence and testimony shows that Mendoza Maintenance Group is entitled to possession. The court, in hearing from Arturo Mendoza, finds that there is no adequate defense as to possession. The court finds that a jury trial has been requested on the day of the hearing. That is too late notice for the court. The court finds that that request is waived. The court finds that there is a request for a lawyer. This is a private civil legal matter, and lawyers are not appointed on civil cases unless there's a request for contempt in jail. That certainly isn't the case here. Finally, I think in defense, Mr. Arturo Mendoza says that a power of attorney was in fact given. If in fact that's the case, the court finds that that is completely irrelevant as to who has the superior right of possession. Therefore, the court's final orders and findings are that Mendoza Maintenance Group, Inc. has full and superior right to possession. These are the orders of the court. They are entitled to, it is entitled to immediate possession. These are the orders of the court, and the orders are due to the court honor before.
July 27th.
All right, so as soon as you file them, I will sign off on them. Anything else on this case, Mr. Martinez?
No,
Do you have any questions for the court, Mr. Jaime Mendoza?
No, there you go.
Any questions for the court, Ms. Margarita Mendoza? Questions for the court, Mr. Arturo Mendoza?
I'd like to have a lawyer help me out.
I understand, and I'm going to repeat what I told you before. There are certain things that I can't do.
Okay.
Not saying I want to or I don't want to, but even if I wanted to, I just can't appoint a lawyer, and I can't handle things of outside of questions of law, and that's the only thing I've done here today. I wish everyone very well. Have a good day.
Thank you.
Page 4, number 10.
There was
In
an
the
inventory.
In the estate of Isabel R. Palacios, cause number 2025 PB 760L2, is there an inventory filed in this case?
Yes, Your Honor.
Court will review that, and that brings this case into compliance. Have all cases been called? This now concludes this docket held in person and by video conference for Tuesday, June 30th, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. For the Webb County employees still here, the clerk's office, the sheriff's office, and the amazing staff at Webb County Court at Law 2, I wish everyone a good day.